Just got under a minute before we formally start the meeting tonight. I know many of you have been before, but for those that haven't, there are some toilets to the left. There is a table if at any point you wish to have a drink and some water. If the fire alarm does go, it will not be a practice, but please, on accessing the building, do not use the lift. I think, Chris, at this point, it'd be a good idea, just rather than me get ravelled up, could you introduce the various officers so people here do know who's representing what tonight?
Yes, Chair. So we have myself, obviously, I'm Chris Dale, I'm Development Manager at the Council. To my right is Denise Knipe, who is she's from Ashbourne Planning, and they have been acting as effectively the case officer for this planning application. Then to her right is Stephen Dudhill, who's the Senior Transport Planner from the county, and sitting just below me there is my colleague Richard from the, temporarily forgotten Richard's surname, do apologise, Richard Ward, who's the Flooding and Drainage Commissioner at the county. Richard's actually come along tonight at my request, because I know that one of the key areas of interest for members of the public is the issue of drainage and flood risk. So he's kind of come along this evening to answer questions on that.
Thank you very much, Chris. Just see. Right, we will formally then start tonight's planning meeting. Can I first ask, are there any apologies for absence, please, that need to be recorded?
Through you, Chair, we have received apologies from Councillor Peter Dobbs, and their substitute is Councillor Joe Linthwaite, Councillor John Boynton, and their substitute is Councillor Anthony Bates, Councillor Nigel Edwards Walker, and their substitute is Councillor Gareth G.
Thank you very much. Are there any other apologies? No? Right. Approval of minutes of previous meeting, that is found on pages 5 to 16 of tonight's agenda. Members will recall that that was chaired by Councillor Lucy Peacock. I wasn't present on that occasion, so is someone prepared to move that those minutes are a true and a correct record of what there and therein took place? It's been moved by Councillor Hughes, seconded by Peter Slack. Thank you. Members, all those in favour, please show clearly. I'm abstaining, so that appears to be unanimous. Yeah, thank you. Are there any interests that members need to declare, please? No? Okay. Now, normally at this point, sorry, Councillor G.
Yeah, could I just make a point? Because I'm substituting for Councillor Nigel Edwards Walker, and I've refreshed myself with the details of this application, and I've been mentored slightly by Nigel, but I've been told I'm not allowed to vote because I didn't attend the previous meeting, and I think that's completely wrong, because if I'm coming tonight
can I
to
ask the
listen to
legal
details,
person to clarify whether or not that is true or not, Kerry?
Thank you, Chair. Councillor G was advised by our Democratic Services that according to our constitution, when an item is deferred, only members that were there when the item was discussed previously can then vote and take part in the, Councillor G can take part in the discussion. But as our constitution stands now, it says he's not eligible to vote.
Okay.
But is there any guidance that the chairman can override that? Because as far as I'm concerned, this meeting is going to take place in public with a lot of public here, and I'm going to listen to everything. So is there any reason why I shouldn't be able to vote? I think I'd like to have that overridden, and I'd ask you to
Do I
look
have
at
the
it.
power to do that, Kerry?
I mean, Chair, yes, you do have certain
Right.
rights in how to conduct the meeting. It's never
Yeah.
a question that's been posed as
Yeah,
of, as
yeah.
of now.
Yeah.
I mean, I can, sort of have a look at exact what the wording was because I wasn't involved in it this
Yeah.
afternoon.
My
But-
personal position would be to allow you that, Councillor G, because you are representing and legitimately here as an elected member of this
Yeah.
council, and I think it's fair that
Yeah.
you should have that opportunity to fulfil that role. That is my personal
And I
point
think
of
you have
view.
that power to override the constitution because you're the chairman, you're in charge.
So,
So I'd like to ask you to do that.
we
please.
either both end up in jail together, or
No, I don't think it's a matter of jail. I think it's the fact that you've got the power.
so that's my stance. That I would personally, as chair, be comfortable that you.
Yeah. So I'm allowed to vote.
Yes.
Thank you very
Yes.
much. Thank you.
Yeah. I want at this point to bring in Richard Ward. Perhaps, Chris, you could. Normally, we would have at this point representations from the public, but Richard's got to go at 7:15, and it's important in his professional capacity. We can listen to what he has to say, then members can actually specifically ask questions, and also back to what you were just saying, in my role as chair, I felt it was important to allow Councillor Dobbs the opportunity if he too wished to pose any questions. So Chris.
Thank you, Chair. I mean, really, it's over to members. There's an opportunity, obviously, to ask technical questions in relation to flood risk and drainage matters directly to Richard here. So, unfortunately, he can only be with us for just over an hour. So, hence him being on at the beginning of the meeting. But really, I guess at your discretion, Chair, it's over to members as to whether they've got any technical questions relating to drainage and flood risk that they'd like Richard to explain the lead local flood authority's position on now.
So from Richard's presentation, it's a good chance on your pads, obviously, if anything surfaces that you would want more information about, this is a good opportunity. And I do thank you from the chair, Richard, for coming tonight to this meeting.
No, thank you for accommodating as well. Thank you.
So we'll allow you to outline whatever it is you feel is important to the planning committee.
Okay, so there seems to be one main area really of concern in relation to the discharge points, the proposed discharge points to the site. Currently, well, in previous, because we originally sent a holding objection because we required further information to be satisfied that there was a viable outfall for the development. So with the information we've been provided to date, the applicant has looked at an outfall both in the southeast corner of the site and also in the southwestern corner of the site. From our perspective, as it sits at the minute, we haven't been provided with enough information to deem the southwestern discharge point viable, because the applicant hasn't provided sufficient information for us to be convinced that it's an acceptable outfall point to convey flow from the site to wherever that outfalls to. So we are, as things currently stand, there's only one alternative discharge point, which is in the southeastern corner of the site, into a pipe which then passes through third-party land into a tributary of Hemar Brook. And I know there's been various concerns with regards to the viability of that outfall point, so I'm quite happy to take any questions in respect of that.
Okay, members. Councillor Hughes? Yeah,
Thank you.
please.
Yeah, thank you. Thank you, Richard, for coming. It's good to see you here. Hope you can come on other occasions too, because your input is always, we often have drainage issues and we often need professional input in our decisions, so it's great to see you here tonight. One of the issues that I think we're struggling with is what the greenfield runoff rate is, and whether the development will, as proposed, will increase the runoff rate above greenfield levels. And two numbers have been punted. One is 0.8 litres per second into a drain, and another is 3.4 litres per second into a drain. And can you outline what your understanding is of the greenfield runoff rate on this site and where it's going and which drains it'll go into?
So, just based upon my previous comments relating to the only viable discharge point as it sits at the minute would be the southeastern corner. So the greenfield runoff for the whole of the site, based upon its developable area, is 8.5 litres per second. Originally it was intended that discharge would be split between the two different outfall points. But because, as things stand at the moment, the southwest outfall point is deemed unviable, and therefore the southeastern outfall point will be the only viable one. Yes, they are proposing to discharge that at 3.4 litres a second, the greenfield runoff rate. So, if you look at the site overall, the overall greenfield runoff site runoff of 8.5 down to 3.4, it would be effectively a reduction if that outfall point was utilised as the main discharge point. With regards to the 0.8 that you've referred to, the 0.8 has been calculated based upon what is perceived to be the catchment of the area of the development which potentially may currently discharge into that pipe pre-development, and that's been calculated based upon the bund at the bottom of the site isn't there. The 3.4 has been calculated whereby the bund at the bottom of the site is present, which it currently is, and therefore there's the potential for an increased area of the site to discharge into that outfall point, and therefore there will be an increase in the greenfield runoff rate from 0.8 to 3.4.
Thank you for that. Can I ask just a supplementary then on riparian rights and duties? So are we saying then that there is an increase in flow from 0.8 to 3.4 in that pipe as a result of the development, or is and that would need there would be a civil matter then to determine that for riparian owners to agree that additional rate?
Yeah, so with regards to the actual rights to discharge into that pipe, so the applicant is currently proposing, talking about the southeastern corner of the site now, the outfall. So the applicant is proposing to make a connection onto this pipe within the confines of the development boundary, which he has every right to do under riparian ownership. We have been made aware of the riparian owners downstream of that would have a duty to accept that flow, providing it doesn't increase flood risk. But we have been made aware of the pipe's current condition from a CCTV report that's been provided, and currently that pipe is not in a fit for purpose condition to accept that flow. There are a number of defects on the pipe. There's one area where the pipe is pretty much partially or 100% collapsed, and therefore that's one of the reasons why we recommended a condition to the LPA I don't know what condition number it is, but I can read it out if it helps. So the condition was, no development shall take place until an assessment of the existing culverted ordinary watercourse from the proposed point of discharge off-site to its outfall to the south-east of Green Road, including any necessary work to maintain the structural integrity and free passage of flow, has been undertaken. And the reason for that is to ensure surface water runoff can be appropriately discharged into culverted watercourse to outfall into the tributary of Henmore Brook to the south-east of Green Road. And that's the reason why we recommended that condition, because we knew what the current condition of the pipe is as it sits at the moment.
And whose responsibility would it be to upgrade or repair the pipe?
As things sit at the minute, if there was no development, it would be for the requisite riparian landowners. We have, as lead local flood authorities, we have powers under the Land Drainage Act to carry out enforcement on watercourses, culverts, land drains, etc. If we feel that there is a risk of flooding to property. So under our current guidance, if there is a risk to more than 5 properties, residential properties or critical infrastructure, then we potentially may consider enforcement. As things sit at the minute, we're not aware of such, and therefore we would have no need to enforce. If the development was approved, you know, that's the reason why that condition is in there. And if the culvert wasn't repaired, replaced, or the requisite work carried out to make it fit for purpose, then it wouldn't meet that condition, and we would have no qualms in objecting to that, because it's critical to the successful draining of that development for that pipe to be in a fit for purpose condition.
So would it be the riparian owner of the pipe that would need to do the work, or would it be the developer who would need to do the work?
I would expect the developer to pick up the cost of carrying out the necessary repair works to that pipe to make sure it's fit for purpose.
Thank you, David. Joe?
Thank you, Chair. Sorry, Richard, can I just clarify? Anybody downstream of this site, across whose land this pipe, the south-eastern one, flows, sorry, did you say they are legally obliged to take anything that's added into that pipe?
The applicant intends to make the connection into the pipe within the confines of the development, and they have every right to do so. And they, you know, the downstream riparian owners would have a duty to accept that, providing it doesn't increase flood risk further downstream. And that's the reason why when any development comes forward, the requirement is to restrict any discharge into, whether it's a public sewer or a watercourse or a culvert or a land drain, to the greenfield runoff rate, to mitigate against any increase in flood risk as per national planning policy. Because that national planning policy clearly states that whenever any development comes forward, it should not increase flood risk, and that's why there's a stipulation that any development has to restrict it to the greenfield runoff rate.
Councillor Lees.
Thank you, Chair. Has this investigation, Richard, has it been carried out from the site right the way through to the Henmore Brook, or is it just the adjoining land?
Are you referring to the camera survey of the pipe?
Yeah.
Yeah, I haven't got the exact, well, I haven't got the details, I can bring them up on a report, but I believe the camera survey could only get so far downstream because the pipe was either partially or 100% collapsed. So whatever requisite repair works the applicant may carry out to make that outfall suitable, I would also expect them to carry out a camera survey all the way down to the outfall to make sure the remainder of the pipe is fit for purpose as well.
So, in effect, then we're looking at probably 3 or 4 different landowners that this could affect?
Potentially.
Yeah.
Any further questions from members at all? Councillor Dobbs, Peter? Yeah, absolutely.
Thank you, Richard. Sorry, it's slightly strange arrangement talking across. Just to clarify, make sure my understanding is correct. Before the bund was built, the clay land drain, and it's a very old butt-jointed clay land drain, drained some of this field, and the runoff rate was thought to be 0.8 litres per second. So the landowner, the developer, built the bund, and because of the change of flow of this development that he's already carried out in creating the bund, it's increased to 3.4 litres per second. Yeah, and that is the flow rate that you believe is can be claimed to be appropriate, although he's done some development to raise it to that amount.
Yeah, I mean, it's. I don't believe he's artificially raised it. We've just based upon the evidence that's been provided that with the bund in place, which is currently how the site sits at the minute, the calculated greenfield runoff rate is 3.4. And if that was the only viable outfall to the southeastern corner, which it currently is as things sit, but I just want to refer back to my original point. The overall greenfield runoff rate for the whole of the site is 8.5 litres a second, and if there was only one viable outfall, that would be reduced down to 3.4 if the southeastern corner of the site was to be used.
Right, thank you, and that brings me actually to my final point, so thank you for that. So basically he's attenuating, flow limiting to this 3.4 because that is what he believes he can discharge under his riparian ownership, and therefore there will be some attenuation pond.
There will be with any development when the discharge rate is restricted to greenfield runoff, which applies to all major development anyway. There will have to be some form of attenuation, whether that be attenuation basins or, I mean, as things currently sit, we promote sustainable drainage, so things like attenuation basins, swales, etc., to manage the volume of water during the storm, to ensure that there is only the greenfield runoff rate discharged from the site during the storm, and then obviously after the storm's passed, the greenfield runoff rate will continue until the basins or whatever attenuation empties.
And on that point of emptying, that would have to be by gravity. It could not be pumped.
Again, it all depends upon the topography of the site. Generally, in the main, it's preferred that gravity is the most effective way of discharging surface water from a site. There are situations where pumps need to be used if it can't be achieved by gravity.
Okay. How many are there in Derbyshire pumped?
I have no idea. Okay. Generally, when you're getting into any kind of pumped situation, well, with a lot of developments, the developer will seek for the on-site surface water drainage to be adopted by the requisite water company, whether that be Severn Trent, Yorkshire Water, etc. And if there's a pump station along with that as well, then they generally envisage that the water company would adopt that asset as well. But we kind of looking ahead, we're getting into the detailed design of how the developer may actually drain it, whether it's by gravity or pump.
Thank you very much.
Councillor Maelstrom.
Thank you. Just back to the pipe repair issue, just to make sure I've understood. If the owners under whose land it passes refuse to repair the pipe, that then means that the developer can't meet the condition. At that point, does the LFA enforce the repair, or does it mean that the project just isn't buildable?
We would have no reason to carry out any enforcement.
Thanks, Chair. I'd like to clarify where the pipe goes. Does it go down Green Road, or does it go down underneath the houses on Green Road? Because they have suffered with flooding in recent years, and adding more water onto Green Road just wouldn't. It's not a go-go for me.
Yeah. Sorry. I mean, as I say, the camera survey that was carried out only managed to get so far down the actual pipe. So the exact route of the existing pipe is unknown at the minute. So there would need to be some further work carried out in terms of assessing the remainder of whatever's not been surveyed at the minute, and also clarify the line of it as well. But you know, if that southeastern pipe is deemed to be viable, again, it has to be fit for purpose and convey flow. So we're aware at the minute that parts of the pipe are effectively an old land drain which is butt jointed. The reason why it's butt jointed is to allow infiltration down through the ground and through the joints. With any modern surface water drainage pipe, I would expect it to be a sealed system, and therefore the applicant would need to demonstrate that it's a fully proper sealed surface water drainage pipe all the way down to the outfall.
Come back on that. I just can't see how, if it's going onto somebody's property, surely it can't be putting this amount of water down.
Well, I don't know whether it's going under a property or not. As I say, the exact line of the pipe's not being confirmed.
If it's going down to them, or it's got to go under one of the property.
No further questions, Councillor Bates. No, that's fine. Right. Councillor Burfoot, sorry, and then Councillor Murphy.
Thank you, Chair. Richard, you mentioned riparian owners. So, should the owner have actually, or the applicant have notified these riparian owners about the construction of the bund and the fact that of the increase from, I think it's 0.8 litres per second to 3.4 litres per second?
I'm not. So, from what I believe, the bund was constructed to try and mitigate against any existing surface water runoff from the site as it sits onto properties at the southern end of the site. That's the only reason why the bund was constructed. It was nothing to do, I believe, with any kind of attempt in order to reduce the greenfield runoff rate. The bund were just purely there to protect the properties at the bottom end of the site prior to any application coming forward. As far as I'm aware, anyway.
Councillor Murphy.
Thanks, Chair. Richard, shouldn't we be a little bit concerned? Obviously, there's some survey work being done. Other aspects of the survey couldn't be completed. There are quite a few still unknowns about the watercourse and where the water will go and where it will flow and whatever. Wouldn't it have been more sensible for us to have this information before we make a judgment tonight? Because the issues will be quite catastrophic for some of the homeowners in that area potentially. As somebody has pointed out, there is already flooding in the area. It's a difficult one for us to be confident in. I know you guys have been very professional in the work you've done, but there are still aspects of this application and drainage where it's a little bit vague.
Yeah, if we're talking about the outfall from the southeastern corner of the site, yeah, I can understand that point of view, but that's the reason why, as the LFA, we felt it was a reasonable and pragmatic way forward to apply a condition in order to cover that particular concern off. So that's why we recommended that condition to the LPA to ensure that if the developer intends to use that outfall point, the necessary works will be undertaken to make sure it's fit for purpose.
final question, yeah.
Of course. So whose responsibility would it be to check and see that this work has actually been done to a standard that would be acceptable by you guys and maybe even the Water Authority?
Yeah, I mean, in relation to any proposed works to either replace or repair the pipes, we'd expect that information to be brought forward at detailed design stage, and obviously whatever is put forward to us at detailed design stage, we'd have to be satisfactory that the design and proposals were fit for purpose, and if it wasn't, then obviously we'd object accordingly. In relation to whether a water company would get involved, any developer has the opportunity to make an application to a water company to get their sewers adopted. Generally, it's within the confines of the boundary and not outside of the boundary. So if the developer does choose to make any repair works or replacements of that pipe, the responsibility of that said pipe would generally still rest with the requisite riparian landowners.
Councillor Lees.
Thank you, Chair, for letting me come back. Just one other, just thought about it. Are we confident that this pipe does actually go to the Enmore and not into the sewage system that's already down Green Road? Because I've witnessed numerous incidents of flooding down Green Road where manhole lids have gone floating down the road and etc. Are we confident it does go to the outfall goes to the Enmore and not into a combined system anywhere? Or do we not know that?
I think it does go to the Enmore. I recall, and you'll have to apologise, I'd have to look back at previous information, but I believe dye tests have been carried out from that point down to the outfall, and it did end up in the outfall to the tributary. So water does eventually end up in there, yeah. It's just the fact, obviously, the fact that parts of the pipe in between those 2 points are in not fit for purpose condition at the moment.
If there are no more questions, then we'll proceed to, Councillor Slack.
Thank you, Chair. Thank you, Richard. The southwestern for was there no evidence of being one there, or was it just people said over the years there was a southwestern flow?
So, colleagues in my team did attend a site visit to look at the southwestern corner. I think, again, I recall, I'll have to look back at the meeting notes, but there was quite a lot of vegetation in that corner, and there wasn't a defined watercourse evident in that southwestern corner. The applicant's representative did carry out a dye test, so they put dye down at the outfall point, and it did end up at an outfall point further downstream. So water is getting from A to B, but with the evidence we've been provided at the moment, we aren't satisfied that we don't know where the pipe goes, is the pipe in a fit for purpose condition, etc. We've asked for that information, but currently we've not been provided with enough information for us to be satisfied that that's a viable outfall point, and that's why at the minute we're deeming it not to be viable. The applicant could carry out further investigations in the future at detailed design stage, but that's down to them at the end of the day whether we do or not.
Just to clarify, the southeastern, would it take all the flow if we couldn't? Obviously, we haven't defined a southwestern one.
Yeah, it would. I mean, a 150mm pipe, which I think that's the size of the existing land drain, can roughly take, and it all depends upon grading, but it can roughly take about 15 litres a second pipe full bore. It depends on the gradient. If the gradient's slacker or the gradient's steeper, it can take more or less accordingly, but on average about 15 litres a second.
Thank you.
No further questions, then it's time for us to proceed to the public. Members will listen with care to your representations now. And welcome back to Councillor Martin Spencer. I think you're beginning to find your way to the Town Hall. So welcome, Martin, and you're representing Ashbourne Town Council. And you've got 3 minutes, Martin, from when you start.
Good evening. Regarding the proposed development at Windsor Close, Ashbourne, on behalf of Ashbourne Town Council, members still feel that this proposed development will set a precedent for further developments on the settlement boundary. It contravenes policy PD2 of the local plan. It isn't an allocated site in the local plan and contravenes policy HOU1 of the neighbourhood plan, which is still in force. Members raised concerns regarding the narrow entrance stroke exit of Windsor Close, which is only suitable for one vehicle, with information in the transport statement being inaccurate. And also the intention of widening the road is not possible due to the land being in the ownership of residents. Members raised concerns that the proposed development will cause issues of flooding on the Green Road, which already floods, and also issues of parking on Manor Road, which already suffers with traffic dropping off and picking up school children. There's no information on managing surface waste and sewage connection, which is already known to be problematic on this large estate. The plan would have a significant impact on residents and their amenities and become a thoroughfare with no provision to alleviate the impact on the town's services, i.e. GPs, hospitals and schools, also resulting in further traffic congestion. The Town Council respectfully requested a site visit, which apparently took place on Monday the 23rd, I believe, 23rd of February, and it's hoped that the DDDC Planning Committee gained a full insight on just how narrow Windsor Close is and the negative impact it would have on residents both of Windsor Close and even Manor Road and Green Road. Thank you for the opportunity to speak, and I hope you will take our objections on board and vote in favour of the residents of Windsor Close, Manor Road and the Green Road. Thank you.
And thank you, Martin, for speaking within time. That's much appreciated.
Okay.
So in a moment, I'll invite Chris Walker. And Chris, you're representing Offcote and Underwood Parish Council, please.
Thank you. I'm the chair of Offcote and Underwood Parish Council, and I have to say that the council is still unanimously opposed to the proposed development of Windsor Close. There are 22 conditions attached to this resubmission, and many of these are broken up into multiple sub-conditions, some of which are general administrative issues to be completed in the final mop-up of the development on completion. But what I am concerned about are those issues which are fundamental to the effective operation and design of the site and its successful completion. Far too many conditions are being delegated to the planning officers, meaning that this planning committee has no control over what is being decided, and therefore the community have to live with the consequences of your decision tonight and have in effect no say in what is decided. This application is for outline planning permission, and as a result of which you as a planning committee are being asked to decide on what is an almost blank piece of paper. You have no indication of the designs of the properties, how they fit into the landscape, the details with the curtilages of the individual properties, the effective disposal of foul water and surface water, how the other essential services are to be integrated into the site, and the upheaval required to achieve all of this. Of particular concern are the proposals for the satisfactory pedestrian access to be provided to serve the site. The calculations, or should I say assumptions, provided by the Highways Authority simply do not stack up. Any reasonable person can see that the proposals for footpath access and shared space with vehicles and agricultural equipment will not work in practice. At best they are unworkable, and at worst they are positively dangerous. This is a case of a public authority, i.e. DCC Highways, making the proposals appear to fit in order to get the application off their desk and allow Derbyshire Dales Council to achieve its requirement for further increase in its housing stock. I've been a parish councillor for 34 years, all of it within this parish, and unfortunately too often I've seen conditions placed upon approvals that are not enacted and enforced. Often what happens is that the conditions, when highlighted, are brushed aside because the development has gone too far and it's too late to turn the clock back. It's very difficult to remove a development once built because the drains don't come up to the anticipated requirement and the flooding becomes a problem, particularly for neighbouring properties. I question whether the Planning Department of Derbyshire Dales has the necessary resources to monitor or effectively enforce all of the conditions in this application, in addition to all the other developments within its area of jurisdiction. And as a result, some conditions will slide, be forgotten, and a blind eye turn to them. I once again ask the committee to refuse the application and not allow so many particularly essential issues to be left to reserve matters. By submitting this application as an outline application, this is in effect a backdoor, meaning of achieving approval with no known final result. I also once again ask to point out that the number of interested people here tonight and the 355 plus entries on the planning portal demonstrates that there is a great deal of public concern about this application.
Thank you, Councillor Walker. I've given you overtime.
Okay.
But,
Okay.
Yeah.
Thank you.
So the next speaker is Lee Noakes from the Windsor Close Action Group. Sorry. Leah, sorry. Sorry, it's Leah. Yeah.
Good evening. My name is Leah Noakes and I live in Windsor Close. We're commencing our representations this evening on the subject of drainage, as this is why the last meeting was deferred. The deferral was specifically for the applicant to show the site is viable by demonstrating a suitable outfall of water. Unless information's been submitted that is not on the portal, the applicant has not demonstrated anything since the deferral. 2 emails have been published between the LLFA and the Council showing that after the last February meeting, the applicant did provide a plan to the Council, which had not been made available before. This plan shows 2 outlets. The LLFA email response seems to say that this plan's been out of date for a year when it was settled that only 1 outlet is viable, which Mr Ward's confirmed this evening. Despite this, the officer's report still says the applicant proposes 2 outlets. There are clearly undocumented discussions and decisions, but the LLFA has confirmed there's no plan which shows what they approved. The situation is now more confused than it was at the February meeting. The point of the deferral was for the applicant to demonstrate viability, and nothing's been done to assess the outfall condition or the route or the capacity. The key question is still, what are you being asked to approve when the officer's report does not seem to reflect the facts from the LLFA? We respectfully request failure to demonstrate a suitable drainage strategy be cited by the members as one of the reasons to refuse this application.
Thank you very much. That was and we now have Kim Dorrington, please. Again, representing the Windsor Close Action Group.
Thank you, Chair. I'm a chartered civil engineer with 43 years' experience, including highways and drainage. Currently, I'm responsible for the independent external review and acceptance of major project gateway documentation for a UK city region combined authority. To me, document control, correctness and quality are of great importance. This application fails badly to meet basic standards in these regards, not least of all concerning drainage, where a feasible strategy is not provided. The southeast outfall is the one outfall considered viable by the LLFA, despite there being no evidence of condition and capacity other than that was provided by objectors. In 2021, by his own admission, the applicant increased artificially the flow from his land into the outfall by more than 400%. This was done by laying a new drain, not by the bund. This is a serious matter evidently ignored by the LLFA, which has subsequently caused worsened waterlogging and overland flows for neighbours who did not give permission for the increase. He now claims this increased flow as the Q-bar flow. If increased downstream flooding risk is to be avoided, the permitted flow into this outpool should be the historical pre-2021 flow and not that flow artificially increased by the applicant. The LLFA recognises that riparian owners are not required to accept increased flows. Why do they accept it here? The applicant states that 16% of the site will not be attenuated. Can this be acceptable? He informs us that a large area will flow directly over the western boundary, as it currently does. Members who attended the site visit saw that the field edge rises up to this boundary, which itself comprises a hedge on an earth mound. Water cannot flow uphill. Negligible flow from the applicant's field currently enters the southwest outfall, therefore riparian owners there are not required to accept increased flows either. Contrary to this and to LLFA requirements, the upper 3 attenuation basins are still stated as discharging into the southwest corner. By reviewing ground contours on the applicant's drawings and the ditch shown at the lowest point forming part of the main attenuation, it's easy to calculate that the outfall pipe from the attenuation basin would need to be around 3 metres below the clay land drain. Therefore, contrary to National SUDS guidance, water would have to be pumped from storage into a butt-jointed clay pipe, imparting further risk on houses close to the southern boundary whose eaves are level with the lowest site ground levels. We consider that the applicant's drainage strategy is ill-conceived, unfit for purpose and cannot meet national guidelines for SUDS, despite the LLFA review, and we therefore request you to refuse it on these grounds.
Thank you very much, Kim. So I'll call upon Chris Robson now, please, again representing Windsor Close, please.
Good evening. My name is Chris Robson from the Windsor Close Action Group, here to speak regarding DCC highways, which was covered by Kim Dorrington at the last meeting. We all expect highways to provide expert feedback and input into the planning process. This is not the case here. Late February 2024, Highways finally accepted their error regarding surface strip ownership. Subsequently, refusal was recommended by DCC due to the lack of footway provision in the close. They cited concerns over active travel strategy and the needs of pedestrians, particularly those with protected characteristics. End of August 2024 saw Highways perform a 180-degree flip from refusal to acceptance. A Freedom of Information request was submitted but denied. DCC and the applicant proposed footpath 10 for foot access avoiding Windsor Close for, quote, persons who are less comfortable. The proposal was dropped as it relied upon works on private property and failed the 6 tests. At the same time, Highways stated that the distances to bus stops were now clarified and are considered to be acceptable. How? Door-to-door distances remain in excess of recognised limits, indeed up to 750 metres. Reliance is placed upon another undeliverable footpath provision across private land to the southeast. Now, Highways propose another unenforceable condition to improve the use of another privately owned footpath, footpath 15, at the extreme northern edge of the site. This is completely unsuitable for those with protected characteristics, and as you will have seen from your site visit. Despite initial concerns, Highways are now proposing a shared space design in Windsor Close. We can find no citable examples of this extended cul-de-sac anywhere in the UK. It does not comply with DCC guidance, as there can be no footway as required. The proposal is not in the applicant's submission, despite this application seeking approval for access only. Highways have accepted incorrect and out-of-date documentation, ignoring their own requests for information, and prompted undeliverable proposals involving land not owned by the applicant. Highways now propose a contrived transformation of Windsor Close into an undesigned shared space through road. Refuse this application because compliance with NPPF and the local neighbourhood plans has not been demonstrated. Thank you.
Thank you, Chris. So Mr. Jonathan Mercer, please. And again, you're representing Windsor Close Action Group.
Good evening. My name is Jonathan Mercer and I own number 14 Manor Road. I would like to address the road safety aspects of this application. At the last meeting, this was addressed by Mr. Coakley, a retired HM Principal Inspector of Health and Safety for the HSE. Following residents' meeting with Director of Place, the LHA requested the applicant produce an RSA1 road safety audit. For clarity, you are being asked to approve both this document and the applicant designer's response. There is an important safety issue you need to be aware of. Firstly, this RSA1 is based on factually incorrect information. The applicant's transport statement and access junction layout documents both falsely imply provision of footways and visibility displays in Windsor Close. This committee is being asked to approve and condition these documents containing these base errors. The LHA accept that it's not possible to locally widen the entrance to Windsor Close, and it's not possible to provide footpaths. This has been repeatedly pointed out to both the LHA and the LPA case officer, but consistently ignored. You heard on February the 24th that the LHA were happy with the application's proposals. You now have the opportunity to ask the LHA questions. It might help your deliberations concerning access to ask DCC officers the following questions. Why they consider the RSA1 to be factually correct, and why they then accept all the recommendations. How has the applicant demonstrated that the increased risk of shunt and head-on collisions from insufficient line of sight distance been eliminated? How has the applicant demonstrated that the increased risk of collisions with pedestrians due to unclear use of road interfaces been eliminated? How does the applicant intend to address the issue of insufficient swept path provision, increasing the risk of collision between oncoming vehicles? And finally, how does the applicant intend to address the issue of insufficient water drainage, potentially increasing the risk of skidding type collisions? Accepting the flawed RSA1 potentially leaves both the LHA and LPA at risk of legal jeopardy. That's important, so I'll say it again. It leaves both the LHA and LPA at risk of legal jeopardy. I put it to the committee that this safety critical matter warrants the provision of a road safety audit produced using the correct information. Thank you very much indeed.
No, thank you. It's now the turn of Mr. Ian Noakes, please. Ian. And again, you're representing the Windsor Close Action Group. I think we went on your garden at one point during the site visit.
Good evening. My name is Ian Noakes and I live in Windsor Close. In October 2025, WCAG engaged Stonemore Civil Engineering Consultants to undertake an independent review of technical highways issues with this application. I will now summarise this and issues related to the review. This is an outline application but not in relation to access. The review states matters related to the availability, design and safety of access cannot be left to reserved matters. Under NPPF paragraph 115, there must be safe and suitable access to the site for all users. This has not been achieved. Sustainable transport modes must be a priority, and this site is too far from public transport. This cannot be resolved. Under NPPF paragraph 117, applications must give priority to pedestrians and cyclists, address the needs of people with disabilities and reduced mobility, create places which are safe, secure and attractive, and minimise scope for conflict between pedestrians, cyclists and vehicles. This application does not meet these requirements. The LHA has not given an opinion, except to say, and I quote, "Vehicle access remains achievable, although it may require multiple manoeuvres. There is nothing to say how pedestrians or cyclists can be safe during these manoeuvres. On a construction site, such multiple manoeuvres would require a banksman by law. So why is this deemed acceptable in Windsor Close, a public highway?" Stonemore also concluded that visibility between vehicles will be a safety concern, particularly for existing residents entering and leaving driveways. This will be even more urgent with construction traffic. The LHA has made a construction management plan a condition, but Stonemore points out there is no alternative access available, so the suitability of Windsor Close for construction traffic must be assessed before approval. The LHA proposed to change Windsor Close into a pedestrian prioritised street, but under their own design guidance, it should have 2-metre footway provision, which it does not. This LHA idea, as there is no design, meets no more than 2 of DCC's own 12 guidance criteria. Stonemore concludes that the scenario of Manor Road with 2-metre wide footways giving access to a shared surface environment along Windsor Close, which would then provide access back to a carriageway with 2-metre wide footways either side, appears to be a wholly contrived network in an attempt to seek to justify an access. Thank you.
Thank you, Ian. And I call upon Patricia now, please. And again, you're representing Windsor Close. Thank you.
My name is Patricia Di Felici, reading this on behalf of Ian Wilson. I want to speak honestly as a local resident about the serious problems with disabled access in this proposal. The needs of people with disabilities and those with protected characteristics have been overlooked. The Derbyshire County Council Planning Streets and Places Manual says that the LHA takes its responsibilities for equality very seriously and knows it is obliged through the Equality Act to have due regard to the needs of all persons. The site is steep, with the main proposed access being through Windsor Close, where there will be no footways and limited visibility. The LHA initially recommended refusal of the plans at first because they didn't address the needs of pedestrians, and particularly those with protected characteristics. The applicant and highways are now proposing the upgrade of a privately owned path, footpath 15, which is unfit for purpose. I live in Atlow Brow, which drops down from the proposed footpath 15 exit from the site. It is a 1 in 7 gradient, far steeper than the maximum of 1 in 12 and recommended 1 in 20 that the LHA requires. For wheelchair users, controlling the rapid descent by hand friction is difficult and can be painful. This cannot be the recommended alternative route for people with disabilities. My granddaughters live in Manor Road and currently play safely with friends in Windsor Close. One is profoundly deaf and unable to hear vehicles approaching from behind. Neurodiverse disabilities are becoming commonly identified. It would be expected that many more children would be walking in the road from the new development to the local schools. Windsor Close is currently a safe environment for children because vehicles entering are slowing down to stop. This would change with through traffic, including delivery vans on time schedules, agricultural equipment and construction vehicles. With no footways in Windsor Close, wheelchair users are forced into the carriageway of a through road and now possibly even over speed bumps with limited forward visibility. A wheelchair user's head is only 4 feet above the ground. This is below the height of the bottom of the windscreen of a typical delivery van. This application does not meet national highway standards and guidelines and fails to comply with paragraphs 115, 117 and 135 of the NPPF. The LHA recommended refusal of this application on such grounds once, but are now recommending approval of something which is worse. I encourage members to refuse.
Thank you very much. Stephanie Sayers, please. Thank you.
Good evening. I'm Stephanie Sayers. My property is on the corner of Windsor Close and Manor Road. Amenity. The NPPF approach to amenity is to set standards for living conditions and environmental equality. One of the core principles of NPPF 135 is to maintain a high standard of amenity. I note that the officer's report confirms that impact on residential amenity is a material planning issue. However, in considering the planning balance, it concludes that there are just 2 amenity objections raised relating to the application: the effect of the new estate on outlook and construction traffic. This is totally inaccurate, as the report does not anywhere acknowledge the scope of the impact that this proposed development would have on Windsor Close, which goes far beyond just loss of outlook and so should carry a much greater weight. The report implies that objections relate primarily to the impact on amenity that would be caused by the presence of houses in a site layout where there are currently green fields. It proposes that potential impact on neighbours should therefore be fully assessed at a later date. It cannot. In fact, the vast majority of objections refer to the impact on residential amenity within Windsor Close, with its conversion from a purpose-built short cul-de-sac to a through road. This conversion is a key element of proposals for access, including demolition of 4 Windsor Close, which would form the narrow vehicle entrance to the development site. For the residents of numbers 3 and 5, the impact on amenity would be particularly severe. With this change of use, the settings of these 2 properties would be radically transformed. An assessment of the full impact on amenity arising from arrangements for access cannot therefore be deferred. This change of use will result in a significant and permanent loss of amenity for all the residents of Windsor Close. The harm is not outweighed by the claimed benefits, and I ask the committee to refuse this application.
Thank you very much. I'll call upon Mr. Barry Orme, please. Barry, you've got 3 minutes, as you know.
I am Barry Orme. I live in the bungalow at 3 Windsor Close. You have received many detailed technical objections to this application. I wish to focus on the human impact. This is the second planning application on this site submitted since June 2023 and is causing a great deal of stress and anxiety. At our age, stress isn't just unpleasant, it's dangerous. Our quiet cul-de-sac of 4 bungalows and 4 houses was likely built with people like us in mind, older residents, some disabled, all hoping for a peaceful place to spend their final years. With one exception, we are all retired, some registered disabled, with an average age of almost 80. We are a community. We help each other with shopping, lifts and companionship. We have earned this calm after a lifetime of work. The proposed development has shattered that calm. The plans show footpaths in the close that do not and cannot exist. The plans also refer to shared access to pedestrians and vehicles. The reality of this statement means elderly, frail pedestrians are expected to share the road with cars, deliveries, lorries, agricultural equipment. Not a great combination, especially for a 90-year-old. It is intended that the bungalow next to ours will be demolished to create a new site entrance. The blind corner created will mean that car headlights will shine directly into our bedroom windows, which is close to the boundary. This is on top of the extra car noise and pollution, which will be made all the worse by a proposed speed calming hump directly outside of our bedroom window. We and other residents have serious concerns on our future ability to access and exit our driveways due to the increased traffic and visibility issues. For example, I will have to reverse my car into a blind corner to exit my drive. Bear in mind some residents in the close rely on mobility scooters and walking aids. With no footpaths, no through road generating more traffic, this will cause great harm, puts us under great risk and is extremely serious danger. Please understand we are not against progress, but this is not progress. It is destruction, it is distress, and it is dangerous for all the residents, especially the elderly, and will result in the undoing of a community. Thank you.
Thank you very much for those comments, Barry. Can I invite Mr. Stephen Liveman now, please? And again, you're representing Windsor Close Action Group.
Thank you for taking the time to listen to our objections this evening. My name is Stephen Liverman from Windsor Close Action Group. If you were anxious about flooding at the last meeting, you should be even more anxious about highway safety, which was never even debated last time. The documents in this application are now outdated, inaccurate, contradictory, or all three. And it is impossible to tell what you're being asked to approve. Paragraph 2.6 in the officer's report sets out documents the approval recommendation is supposed to be based on. The same documents are listed in condition 3, stating development must be carried out in accordance with them. The transport statement is from January 24 and has never been updated. It states that the 2-metre wide footpaths can be installed in Windsor Close, and that was proved to be not the case 2 years ago. The LHA objected to that report and nothing's changed. Nothing in the applicant's documents mentions a pedestrian prioritised street design. This is a contrived creation of the LHA, and it's not mentioned. There is no design for this key issue. The flood risk details are from 224. The LLFA have recently confirmed there is no written drainage proposal from the applicant, and that reflect what the LFA says is acceptable. The case officer is stating that version 6 is the approved access junction layout drawing. Version 8 is the most up-to-date, and although DCC Highways have already said that it isn't acceptable, there is no definitive proposal from the applicant correctly describing the access proposals. Road levels, gradients, swept path analysis for emergencies and service vehicles and speed management are all either reserved matters or conditions. You're being asked to decide if this is a safe and suitable access without any of the details. If this is approved, you risk blood on your hands. The transport statement listed condition 3 states that the agricultural traffic will come through Windsor Close. Condition 7 says the agricultural traffic needs to go via existing access. The arboricultural impact assessment states that 3 trees must be removed for health and safety reasons, but subsequent information says there is to be no tree removal. Condition 18 is therefore undeliverable, requiring tree fencing, which will be impossible to work round.
Unfortunately, Stephen, I've given you overtime, so please conclude.
Okay, yeah, I'm on the last sentence. This application has been going on for so long and the documents are so outdated and contradictory, there's no justifiable way to approve. I ask the committee to refuse this application.
And then finally, before I bring in the ward member, Councillor Peter Jobs, it's James Pavey of Windsor Close. Thank you.
Members, thank you. No one likes to hear from a lawyer once. To listen to me twice, I'm very grateful. I still act for Angela Hunt. She still lives at the Green Hall. She still owns and she's the custodian of the Green. But perhaps particularly important in light of the discussions you've had, she's the owner of a large section of that clay pipe. You will, I hope, have seen the letter that we wrote and was posted on the council's website on Friday. And what I tried to do, Councillor Hughes, was address your question, which sat at the heart of the motion to defer, precisely and with intellectual honesty. Is the site viable insofar as it can discharge into a suitable, which the officer's report omitted, suitable watercourse? Since then, the applicant has added, as far as I can see, absolutely nothing. The County Council, as the lead local flood authority, has signed off, it appears, on the southeastern discharge on the basis of the information that the applicant has provided. And we saw the emails on the website in March. But what we've heard this evening, I found absolutely illuminating. There's no great confidence at all in the information that the applicant has provided. You heard that from the officer. There was just a pragmatic decision to actually deal with this by condition, effectively kicking the can down the road. The 2021 works to create the bund, increase from 0.8 litres per second to 3.4. Whatever the motive, that happened. But there was no corresponding increase in right to increase the burden on the downstream owners as a matter of law. It doesn't matter on the motive, but that's key. You've heard an imprecise legal analysis of what increase in burden the applicant is actually allowed to impose on the downstream owners, my client and no doubt others. It's not that the applicant, that everyone downstream has to avoid anything that will stop a flood risk. It's actually that the applicant can't materially increase the burden, certainly above the existing pipe. Otherwise, there's an actionable nuisance and they can be sued for it. And lastly, you heard that if the landowner won't permit the digging up of the green to actually impose a new pipe in there, much bigger pipe for the increased runoff, they won't enforce. So on a planning analysis, on a property analysis, that is the end of the matter. Particularly because my client, as the owner of the green, won't permit it to be dug up for that purpose. That kills it dead. Just to add another point, the point about conditioning this, you can't condition the creation of drainage rights. You can't really condition for the effect of rainwater and gravity. That's a matter of common sense. But to come back to what I said last time, 3 objections from my client: surface water drainage, access via Windsor Close, you can't condition it wider, and the harm to character and appearance. This is a terrible piece of town and country planning, you should refuse it.
Thank you very much, Dave.
Thank you for the
Yes, Richard, thank you very much for coming. Councillor Peter Dobbs, you're the ward member now. You have 5 minutes, please, as and when you're ready, Peter.
Thank you, Chair. Members, see you around the corner. As you have heard, this application is characterised by inadequate capacity of infrastructure pushed well beyond the limits of its design and, frankly, into conjecture. It is pertinent to note at this point that one of the MPPF requirements to refuse an application on highways grounds rests upon showing that it has an unacceptable impact on highway safety. This can be assessed by a road safety audit, and although it's not apparent from the officer report, 2 have been carried out. The applicant's audit by Seven Airs Consulting contained incorrect assumptions that made suggestions for a solution undeliverable. Principal amongst these was the assumption that the service strips were adopted and available for road widening and forward visibility. They are not. Despite these shortcomings, the LHA have accepted the applicant's response to this audit, even where the designers have said they cannot comply with the recommended action for local widening. In contrast, Highways appears to have ignored an RSA commissioned from Tootham Consulting by the residents in June 2025. This found several unresolved hazards. The officer report makes no reference at all to these findings, or the fact that issues from the applicant's own road safety audit have been left unaddressed. The assumption seems to have been made that because this is an outline application, these details can be sorted out at the reserve matter stage. This does seem to be the worst kind of it will be all right on the night approach. Facts of land ownership, availability and ground levels will not alter. If there is not an engineering solution that can be proposed now, then on what basis is it appropriate to assume one will be available later? It is also surely not acceptable in planning terms to defer any detail of the access requirements to the reserve matters stage when the application before you today is for access. To recap, the proposed route in and out for vehicles is via a road that narrows to less than 4.6 metres, was originally recommended for refusal by the LHA in February 2024 due to a lack of a safe pedestrian strategy. It's too narrow to allow a refuse truck to comfortably pass parked cars, yet it's considered adequate to allow safe access for construction traffic. With no land ownership with which to achieve it, Windsor Close has been rebranded as a pedestrian prioritised street and said to conform to a design code in the LHA's planning streets and places. Leaving aside the fact that this code is targeted at new build estates, it fails in several areas to meet the requirements, with perhaps design, speed and visibility displays the most obvious inadequacies. To turn to issues concerning the drainage of surface water on the proposed site, contrary to the impression given at the previous planning meeting, we now hear that the LFA state there's only one viable outfall from the site, a butt-jointed clay land drain at the southeast corner. If those of you who were present on the site visit in February may recall, this is the corner where the site visit began. You may also recall an earth bund on the left of the track through the site against which water was pooling. This is a site that currently drains poorly and, more importantly, does not to any great extent currently discharge through the land drain that the applicant now intends to use to drain the entire site. Site Feasibility Plan 20H has the topography of the site clearly marked, and this confirms why water would collect where it has done. Now, the applicant can reprofile the site to suit and clearly apparently intends to create a suds attenuation basin of some 500 odd cubic metres in the lower part of the site. However, he cannot expect such a pond to discharge unaided into the land drain unless the outlet of the pond is higher than the land drain. The lie of the land and the location within his own land of the only drain that is approved by the LLFA means that this simply is impossible to achieve without a pump system, and all the environmental and flood risk that's implied by that. There is just too much in this application that's inaccurate, inconsistent, or inadequate in detail, and a refusal is the only safe decision. Thank you.
Thank you very much, Peter. And then I want to turn to our final speaker, the applicant, Mr. Adam Rutland. And Adam, you've got 5 minutes.
Thank you for the opportunity to speak again today. We were not cited on the solicitor's late correspondence at the last meeting, which was unfortunate, as we could have highlighted some of the inaccuracies within it. For example, MPPF paragraphs 110 to 12 relate to promoting sustainable transport, not highway safety, and paragraphs 152 to 9 protect the green belt, not flood risk. The reference tree removal when none are being removed, and other representations often refer to unrelated or contradictory statements. For example, we just heard, if as claimed by the Windsor Close Ashbourne Group, current overland flow cannot enter the ditch by percolation on the southwest boundary, then by default, all the current 8.1 litres a second must flow to the southeast, contradicting other Action Group claims. This is symbolic of the confusion and misinformation that surround planning applications. If solicitors struggle to get it right, how can we expect the wider public to? That is why I ask you not to take my word for it, but instead to listen to the direction of the 5 recent planning inspectors whose decisions are directly relevant, and ask that you give due weight to the professional consultees on the officer's report before you today. Their conclusion is clear. There are no defensible grounds on which an objection today could be maintained. Reviewing the recent local appeal decisions proved that the main topics raised today, primarily highways, drainage and landscape, simply do not withstand scrutiny, and have all been dealt with repeatedly, and none were found to justify refusal. First, highway safety. The Biggin View Hull and Ward application was refused by a committee due to concerns about shared space arrangements, but was allowed on appeal in November 23. During the inspector's visit, a car was parked in the way that forced pedestrians into the carriageway. The inspector, citing Manual Streets, concluded that it satisfied public sector equality duty requirements and that motorists behaved more cautiously in such environments, and found that no harm to those with protected characteristics. Similarly, at Leeds Farm Ashbourne, in a 60-mile-an-hour zone, concerns were raised about unlinked footpaths, visibility and potential collisions, and the proposed pedestrian link was removed shortly before the hearing. The inspector found no unacceptable highway impact and no conflict with local plan policies, and the appeal succeeded in June 24, confirming that such concerns do not justify refusal, especially when, as here, highways raise no objection. Second, flood risk and drainage. The Throttleness Way Brailsford appeal, allowed in February this year, discussed drainage concerns. The inspector accepted that local infrastructure was performing poorly, yet placed significant weight on the agreement between the expert witnesses using the HR Wallingford methodology. The key principle reaffirmed was that whilst new developments was not increased flooding, it is not required to fix pre-existing problems outside of their control. By retaining water and releasing it in a controlled manner, the proposal did not worsen downstream conditions and could improve them, fully complying with national and local policy. The same logic applies here. Our site has a proven discharge point, reduces runoff with no pumping required, LLFA support, and hence there is no defensible basis for refusal. Third, landscape and character. Last October, the inspector for Hawthorne House Clifton appeal acknowledged that given Clifton's lower settlement tier, that there was a moderate landscape harm, but still allowed the development because the district's housing need outweighed that harm. They also stressed MPPF paragraph 73 in the critical role of small and medium sites in meeting the housing requirements. Similarly, the Main Road Brailsford appeal in September 24 considered heritage, highway safety and loss of agricultural land, concluding that the public benefits clearly outweighed the concerns. The parallel benefit with today's application are clear. To conclude, this site lies adjacent to a Tier 1 settlement, exactly where the policies say growth should be focused. It is in a flood zone 1 with solutions that reduce runoff. from 8.1 to 3.4 litres a second. It has LLFA and highway support, and significant weight should be given to this. It is within walking distance of local schools and amenities. It delivers biodiversity net gain and 30% affordable housing. And with only 1.36 years of housing supply, significant weight must be given in favour of approval. The appeals I've cited, Hull Ward, Ashbourne, Clifton and 2 in Brailsford, prove that in even more challenging locations, the parallel concerns raised have not been upheld, but will deliver significant benefits. I hope that this committee, given these facts, the very strong appeal precedent, the consultee's support, the lack of housing supply and specifically the officer's recommendation for approval, all agree that there is only one reasonable conclusion to approve this application today. Thank you.
Thank you very much. Can I just simply, at this point as chairman of the committee, express my thanks to everyone. There's been great thought and care put into the presentations, and I know all members have listened with care to what has been said tonight at this point in the planning meeting. What I'm going to propose is that we now have a break for 15 minutes. I want members to look at correspondence, please, that's in front of you, and then if members of the public wish to use the toilets or have a drink, but we'll reconvene just before 1:45, please. Can I just ask, our members now seen the late representations, are you satisfied that we can continue? That all right? Right. We're going to now formally continue the meeting from the adjournment, and we're on page 19 of the agenda, pertaining the outline application for the erection of 30 numbered dwelling houses and associated access in brackets re-submission land northeast of Windsor Close, Ashbourne. Now the case officer is from Asbury Planning, Denise Knight. Denise, so I'll invite Denise then please to outline your report.
Thank you, Chair. The application is represented for determination following a deferral on the 24th of February committee to allow the applicant to demonstrate that they can connect to a watercourse on land in their control. A plan has been provided and the lead local flood authority consulted, who maintain no objection to the proposal subject to conditions as suggested. To recap, the application is a resubmission of an earlier application for 42 dwellings and is seeking outline consent for 30 dwellings with access only for determination today. All other matters are reserved. The site is a 1.65 hectare greenfield parcel of land outside of the settlement boundary for Ashbourne, but is adjoining the settlement. The field is enclosed by hedgerows interspersed with mature trees which are to be retained. The access is proposed from Windsor Close, facilitated by the demolition of number 4, which is in the applicant's ownership. The applicants also own the field to the rear of the application site and want to retain an agricultural access. This is currently provided from the Green Road and this arrangement will continue. Retractable bollards are proposed to prevent other vehicles from using this access, as shown on the indicative layout plan. Moving through the slides, slide 3 shows the application site in context with the northern built-up edge of Ashbourne and land in the ownership of the applicant. Slide 4 is a zoomed-in plan of the application site, and slide 5 shows the site in context with Ashbourne's neighbourhood plan. The site is denoted by the red star, which is outside of the settlement boundary. Slide 6. This shows the public rights of way around the site. You will see FP10 to the south and FP15 is to the north. The next slide shows the positioning of the photographs that I will be going through. Next slide shows 2 photographs taken from Atlow. Sorry, just moved up. 2 shows from Atlow Brow from the footpath FP15, northwest corner of the site, and views across the fields towards the manor farm. The next slide is also from FP15, but looking across to the east boundary. The next slide is taken from Atlow Brow at the start of FP15. You can see the end of the tarmac, which marks the end of the adoption. A connection here is proposed from the application site. The next slide, this is the entrance to Windsor Close. You can see the tree behind number 4, which is subject to a TPO confirmed end of last year. The next slide is taken from a car upon entering Windsor Close. Number 4 is at the head of the cul-de-sacs, and you can see number 3 and number 5 on either side. The next slide is taken from the next slide. The next slide is taken from the Green Road, a private access which the applicant has a right to use. The next slide is showing an indicative layout that has been provided to show a possible arrangement of 30 dwellings with access from Windsor Close and a connection to the FP15 in the northwest corner. Agricultural access were taken from the southeast corner, which will have a controlled access to prevent residents from using this entry. Access into the site is from Windsor Close, facilitated by the demolition of the existing dwelling. The next slide shows the access design from Windsor Close, which has been subject to lengthy discussions with the Highway Authority to overcome concerns related to gradient and carriage width and speeds. A gradient of 1 in 20 with a maximum gradient of 1 in 12 can be provided, which the HA considers acceptable. The next slide details the horizontal and vertical alignment of the proposed carriageway to address concerns raised by the HA over the gradients and walkability of the layout. The application is also supported by a road safety audit and a walking, cycling, horse riding assessment, which the Highways Authority has set the conclusions. The next slide shows the route protection plan around the TPOs and the other trees in the area. The next slide is a zoomed in image of the route protection zone around the TPO tree. It shows that an area of the internal road would be within the route protection zone, and a no-dig solution has been put forward, supported with technical information on a cell web system, which has been assessed and raises no objection from the tree officer, subject to adequate arboricultural supervision and guidance when construction on works are close to the trees, including when installing the cell web-based service. The Highways Authority have not raised any objection to the proposed method, but the details will be subject to the formal consent under the Highways Act. Moving on to the principle of the development, the Council currently has a 1.36-year housing land supply, well below the 5-year requirement. This engages the NPPF tilted balance. Local Plan Policy S4 allows for housing adjacent to Tier 1 settlements in the absence of the 5-year supply. Ashbourne is a Tier 1 settlement. Therefore, the principle of housing on this site is acceptable, subject to the assessment of other impacts. The application has attracted substantial objections from residents. Windsor Close Action Group have provided independent highway reports contesting that a suitable and safe pedestrian access can be provided. The report has been reviewed by the Highways Authority, who maintain that the proposal would not amount to severe harm and raised no objection to the proposal, subject to conditions as outlined in the committee report. The trip generation is modest at around 15 two-way movements at AM and PM peaks. This does not trigger severe residual impacts as advised in the NPPF para 116. The Highways Authority are satisfied that the Windsor Close can function as a pedestrian prioritised street, keeping traffic speeds low. It is advised that this matches existing behaviour on the cul-de-sac as present. A new pedestrian link to FP15 provides an alternative walking condition, safe walking route, and a Grampian-style condition requires improvement before occupation. The internal layout will be subject to a further review with a reserve matters application. The local Highways Authority is satisfied that there is an engineered solution available and there is no justifiable reason to seek further detail at this outline stage. The ash tree at the entrance concerns have been raised by residents, the potential loss of the tree as a result of development and the creation of the access. Whilst there is some encroachment into the route protection area, a no-dig construction method, cell web, is proposed. Highways accept that retention is possible in principle, but advise that technical construction details must be proven at reserve matters stage, and this has been conditioned. All trees are to be retained on site, and a condition is imposed to ensure that. The site lies in flood zone 1, a low probability of flooding, and the EA raised no objection. Windsor Close Action Group commissioned an independent report detailing existing drainage and pooling issues on the site and flooding to neighbouring properties, and consider that the proposed drainage of the site is inadequate. The report includes photographs of neighbouring properties during a flood event, showing water runoff from the fields spilling over retaining walls into the ground. This is an existing problem. The application is seeking outline consent with all matters reserved. However, policy requires proposal to address any potential flood risk as a result of the development. The outline drainage design is, as contained in the Flood Risk Assessment Appendix 1.2 version, consists of swales and attenuation ponds, and the lead local flood authority raised no objection. Following the deferment, the applicant has provided a plan showing 2 possible connection points within the application site. The lead local flood authority considered that the south-west connection has not been demonstrated to be suitable and further investigations is required for the south-east connection and have recommended conditions. They do not object to the proposal in principle. Ecology and biodiversity. Objections have been received by residents citing loss of wildlife and impact upon bats. Derbyshire Wildlife Trust initially requested further bat surveys, but once the applicant committed to no tree removal, Derbyshire Wildlife Trust withdrew their objection. Condition 7 prevents the tree removal unless prior consent is required. A bat survey would be required if trees are to be removed. The application was submitted prior to the mandatory requirement to provide biodiversity gains. There is a policy requirement to provide at least 10% gain, and this can be secured at Reserve Matters Stage 3, a biodiversity retention and enhancement plan. Manor Lodge and Manor Farm lie to the east and residential properties lie to the west, backing onto the application site. The indicative layout plan shows a possible arrangement of the dwellings showing an acceptable separation distance and avoidance of overshadowing can be achieved. No. A further objection has been received stating that the report does not adequately assess impact upon the residents on Windsor Close. It is a fact that the residents will have a change in environment from a short cul-de-sac to an extended cul-de-sac. The submitted transport statement advises that there would be an increase in comings and goings as a result of 30 dwellings, equating to 15 two-way movements at peak times. Whilst it is modest, it will have a level of impact upon the nature of the cul-de-sac. The creation of the access will have some impact upon number 3 and 5 Windsor Close as a result of traffic and pedestrian movements to the side of the dwellings. Number 3 contains a window at ground floor level set behind a brick and timber boundary. Number 5 contains no windows in the flank wall. The access road as shown will be approximately 10 metres from both dwellings, whose principal outlook is looking down the close and over the application site to the rear. Dwellings fronting a highway is a typical arrangement for residential estates and is an acceptable arrangement. The separation distance from the access road is considered to not lead to a significant or adverse impact upon the enjoyment of the dwellings. The site is not within a conservation area and no harm to statutory heritage assets has been identified. The Conservation Officer has identified some minor impact to the setting of Manor Farm, which is a non-designated heritage asset, but this is less than substantial and outweighed by the significant public benefits, particularly housing delivery. To conclude, the Council's 1.36-year supply means very significant weight is given to the housing delivery. The site is adjacent to the settlement in a location acceptable under Policy S4. There are no technical objections that weigh against the proposal and conditions are imposed to ensure safe access can be constructed and a satisfactory drainage scheme comes forward. There will be a level of harm to the residents of Windsor Close with an increase in movements by extending the cul-de-sac, but this is not considered to be demonstrable or significant. The benefits of housing delivery and non-affordable housing are benefits which are considered to outweigh the limited harm identified. Accordingly, the recommendation is to approve outline consent subject to conditions and a Section 106 agreement as set out in the report. This is with the exception of Condition 3, the approved plans condition, which is to be amended to only refer to the access junction layout as other relevant documents are cited in relevant conditions and are not needed here. Thank you.
Members, when I'm at chapel on a Sunday, there's nothing worse than a long, laborious sermon. We're moving now to questions, and I do ask of you, please be concise. It's not an opportunity for statements. You've heard the planning officer. I'm glad that we've got the presence of Stephen Dunhill, Senior Transport Planner from Derbyshire County Council. So the floor is open for questions, please. Councillor G.
Yeah, thank you. The agent for the applicant made a statement that he said that this site was where growth should be focused in the existing local plan. Now, I understand that that is majority around Tier 1 settlements, but is this actual site outside the settlement boundary of the existing local plan? And is it a growth site? I mean, is it a site, is it normal to accept development beyond the settlement boundary, even though the council's adhered policy currently, because it obviously is struggling to come up with a new spatial strategy, but is this actually contravening the existing local plan?
Thank you, Councillor G. That's excellent. Could you respond, please?
So the answer to that is the policy does allow for edge of settlement expansion where the in the situation where the housing land supply is insufficient. So it's not contrary to policy in that regard, but it is outside the defined settlement boundary.
Come back, Councillor G, with a supplementary question.
Yeah, I just find it slightly bizarre that we have settlement boundaries, and we have a focus on growth, but we can just contravene it if we feel because we're desperate to meet the housing targets. It doesn't make sense to me because you either have a settlement boundary or you don't have one. And I've seen this happen in my village in Cryche. We had a settlement boundary that was put into the neighbourhood plan, and the planning, the planners just completely ignored it. And that seems to be happening.
Question, Gareth, please.
Yeah, so is it normal to ignore a policy that we've put in place?
Chair, yeah, I mean, that is unfortunately the case where the council's housing land supply is less than 5 years. The council is required to have regard to the need to provide 5-year housing land supply. It's currently just over 1 year, so there are insufficient sites currently being delivered for housing. So in this instance, it is justifiable. The MPPF refers to a tilted balance where the council doesn't have sufficient housing land supply. There's effectively a balance and presumption of what's termed sustainable development. That means that even where some harm is identified, it might be landscape harm, it might be some other type of harm, that has to be weighed against the significant benefit of delivering new housing. So it's not unusual, and in fact, in comparison, for example, to a site that was separated from a settlement, this site is more rational in that regard because it adjoins an existing settlement and continues it on, rather than being development out in the open countryside, for example.
Okay, thank you, Chris. Councillor Hughes.
Thank you, Chair. I've got one or two questions on conditions. Condition 4 says no development shall take place until full details of site access, etc., is determined, with a maximum 15 for access at a maximum speed of 15 miles per hour. I think that's quite standard, but if we go to the diagram showing the tree protection, you can see that the driveways either side of number 4 would make access and entry and exit from those driveways difficult because there wouldn't be enough visibility splay from those driveways to see whether traffic was coming down from the new development. So if it was a new house being built there, then highways would ask for visibility splays that were sufficient to see vehicles doing 15 miles an hour. So what is the why is a new road allowed that breaks that requirement? So the new road now creates a problem for the people exiting the driveways because they won't be able to see vehicles sufficiently far up the new development to determine whether there's a car there or not that's moving at 15 miles an hour. That's my first question.
Could you give a response to that, please? Thank you.
Yes, thanks, Chair. The two properties you're referring to, the number 4 and number 3 and 5, sorry, so north and south of the proposed access. If we deal with number 3 first, you'll see that the alignment of the, I've got a scheme up there. The alignment of the road moves to the south as it progresses beyond number 3. So the splay requirement from the driveway to number 3 would be accommodated to the tangent, northern carriageway tangent edge of the new road there. So that would then allow people leaving number 3 to see all the way through to beyond that initial bend into the site and towards vehicles coming towards them with more than sufficient visibility to meet the 50-mile-an-hour design speed. You can see on the P6 drawing, you can see the visibility splay lengths for the 50-mile-an-hour splay distance, and they go just a little bit beyond the bend to the east of the driveway to number 3. Number 5, similarly...
Chair, could the diagram be displayed so we can see what...
Is it possible, Chris?
Probably the site layout would...
The one with the tree.
The illustrative layout drawing. What's that, P6?
Oh, back.
The tree protection drawing.
That one.
There we are. Right. So, Chair, again, if we deal with number 3, you can see that the road bends to the south as it goes eastwards into the site. And at the point of access, there's a 2 metre wide margin. So at that point, you would get probably more than a 2.4 metre by 50 miles per hour equivalent splay length from number 3. Similarly, from number 5, you can see again you've got the 2 metre margin where the vehicle would emerge from number 5, providing forward visibility back into the site beyond the bend. So the visibility displays will be accommodated within the new access arrangement.
David, would you like to ask a supplementary?
I've got some other... Thank you.
Right.
I have some questions on some of the other conditions. And it's really, can we change when the conditions apply? So, for example, it says a number of the conditions are about the conditions should be fulfilled before occupation or before development takes place. But there are one or two, I think, are design elements that should come to the reserved matters. It should be included in the reserved matters application and not left until after reserved matters, so members of the public can see what is being proposed. So can I ask whether we can change conditions where it says before development takes place to before at reserved matters such and such will happen?
Chris, could you respond?
Chair, yes, I can. The answer is yes to that question. That the conditions can be reworded to that effect so that matters come forward at the same time as the reserved matters.
Thank you.
Any more questions, David, at this point?
Stop.
Right, okay, thanks. Councillor Sue Burfoot, and then it's Councillor Peter Slack.
Thank you, Chair. I have got 3 questions, and they all for Stephen. And could I just say thank you to him for coming from the local highway authority, because we don't get them normally, do we? No. So my first question is, I understand that there are 12 key parameters required for a shared surface environment. How many of the 12 are achievable if this development was to go ahead?
Could you list the 12? I'd have to go through the Planning Streets and Places guidance to look at those 12, but do you have any in particular in mind?
I kind of assumed that you'd know what they were. I don't know where to find them, but...
Yeah, the simplest way of dealing with that is that in terms of the layout within the site, which is illustrative, the layout within the site can comply with the requirements for pedestrian prioritised streets as set out in Planning Streets and Places. So that's a given. That would meet all those specific requirements. We're then dealing with the issue of off-site impact along Windsor Close, and clearly what we don't have along Windsor Close are footways, but again, substantially most of the requirements for pedestrian prioritised streets are met along Windsor Close, because pedestrian prioritised streets are permitted to have service strips, which Windsor Close has. The widths are consistent with the Planning Streets and Places guidance. the radii and geometry consistent with planning streets and places guidance. So from a highway safety perspective, considering the off-site impacts, the Highway Authority concludes there's no unacceptable highway safety impact along Windsor Close.
Thank you. The second question is about the, I don't know how you say this, Tootham RSA. Did the local highway authority actually give consideration to this report that was commissioned by the Windsor Close Action Group, as I understand it?
Tootham RSA came in after, I think, the Highway Authority issued its observations in August last year when conditions were recommended. I've looked at the document since then, and my conclusion would be that the report doesn't change the Highway Authority's position. There are essentially two issues raised in the report. The first issue, safety audit reports identify problems and they make recommendations. The first issue identified a problem and then recommended the solution. And I think that related to trying to maintain design speeds or low speed along Windsor Close. The second issue, I think, was concerned with the movement of refuse vehicles or delivery vehicles. And actually, there will be no change effectively arising from the development because, for example, in terms of refuse vehicles, it's the same refuse vehicle serving the proposed development as would currently serve Windsor Close. So there's no net impact. So those two issues weren't material to our consideration, didn't affect our conclusion.
And the final question is a little bit more complicated. So, as I understand it, as the local highway authority, we are satisfied that Windsor Close, and I'm quoting here, that Windsor Close, if extended, would operate as a pedestrian prioritised street, and that the detailed design of the transition feature at the site entrance is critical to reinforce pedestrian priority and maintain very low vehicle speeds. I'm quoting here. Would this need to be addressed at reserve matters? And am I correct that a detailed design hasn't actually been done? Because I'm not really clear what these transition features at the site entrance might be.
Yeah, two aspects then in response to that question. Firstly, the applicant, by submission of the drawing reference P6, has demonstrated the feasibility of access into the site, so that satisfies the access issue. The second point is that what we're dealing with is trying to ensure that vehicle speeds along Windsor Close remain low. And that's where the transition features come into play. There could be a range of different transition features ranging from block paving, changes in surface texture, amendments to the mouth of the junction of Windsor Close with Manor Road. For example, you could continue a footway across that bell mouth and comply with our planning streets and places guidance. So a range of factors, all of which we'd be looking for the applicant to come forward with at subsequent stage, and all of which would be subject to condition number 4, which requires submission of those details for approval.
Councillor Slack, would you like to ask your question, please?
Thank you, Chair. Two questions. The first question is the link road and narrowness of the link road. In peak times when there's traffic coming both ways from the new side and out of the into the new side, out of the new side, if you get heavy vehicles coming through there will be a stop. They'll have to stop while they negotiate to pass. But there's going to be a build-up of traffic over a peak period, isn't there? Both ways in that area. You can't really stop that, can you?
I wouldn't agree that there would be a build-up of traffic, and that's the key point. When you look at the level of traffic impact arising from the proposed development, as referred to in the planning presentation, the transport assessment or transport statement estimated the level of traffic flow arising from the new scheme, and the peak period flows forecast are about 15 vehicles an hour. That's a two-way flow. The one-way flow as a component of that is about 11 vehicles an hour, so 11 one-way, 4 the other way. So, peak directional flow amounts to about 1 vehicle every 5 or 6 minutes through the peak hour. And you can see there are quite substantial headways between movements passing in opposite directions. The flows on Windsor Close currently are much lower than that, at present. So it's unlikely that you'd have a significant degree of conflict between traffic moving in two directions along Windsor Close arising from, you know, the level of traffic generated by the proposed development.
Yeah, I realise that, but if you've got agricultural vehicles, great big machines coming in to do the agricultural work, you're bound to get a blockage. You won't be able to pass them sort of things. They'll have to come through and the others will have to wait.
The intention, as I understand it, is that the agricultural access would remain as existing, so it wouldn't actually come through Windsor Close. It would come across the green to the east.
That's related to my second. That's related to my second question now. My second question is, why can't some of that traffic come across the green and through that way? Is that what you're planning to do, agricultural traffic? It would make sense, because it would take it away from Windsor Close.
Yeah, if you refer to the illustrative layout, the illustrative layout shows agricultural access across the green. So to the east of Windsor Close, not coming through Windsor Close. That's the.
Oh, right.
I think that's the applicant's intention. The applicant's nodding.
Well, that'll improve. You know, we're not coming through Windsor Close. Will make it better.
Well, I don't think they come through Windsor Close at present, so there would be no difference, effectively, in terms of the impact on Windsor Close.
Okay. Yeah. Thank you.
Thank you, Peter. So, Councillor Linthwaite, please.
Thank you, Chair. Sorry, Stephen, two more for you. I just wanted to pick up on Councillor Hughes's question about number 5. As I understand it, if I remember correctly, as you're looking up the close as it is at the moment, you've got 3, 4 and number 5, that there's a boundary fence that runs between number 4 and number 5, which comes down the length of their driveway. I'm looking at them. Yes. So when they're pulling out of their drive, will that fence not restrict their visibility for traffic coming off any new development? And if so, is it up to them to do something about that? I wasn't quite sure.
No, I don't think it does, because I think the fence extends as far as the boundary of the service strip, so not as far as the carriageway.
Is that right? Okay.
So the service strip, the width, about 2 metres, allows you for that visibility back along the service road, the new road, sorry.
Okay, thank you, that clarifies that. My second question was really, I think, sorry, there's a head in the hands moment again. I think for us lay people and for the residents, they find it quite hard to understand some of the rules and regulations around what's acceptable and what's not in terms of widths. So on Sunday I tried to look at it in terms of my own experience of that close, which I understand at its narrowest is 4.57 metres. Well, I have a Fiat 500 and I checked the width of my car from wing mirror tip to wing mirror tip and it's 1.68 metres. So if I take that away and I meet another Fiat 500 on that road, that leaves 1.21 centimetres to pass, to share between the two vehicles passing and the service strip, and having a gap between the two cars and the service strip on the other side. That doesn't sound very much, and that's with 2 small cars. And I'm just wondering how you envisage it working if this goes ahead and you've got construction traffic coming up and down there. Because, I mean, I appreciate your comment about the dustbin lorry, but I imagine residents know what day the dustbin lorry is coming and they limit the amount of cars that are parked on the street on those days. But when you've got I couldn't quite see how it was all supposed to work with construction traffic on such a narrow.
Sorry.
It's just, could you explain to us how you envisage it working on such a narrow street?
In relation to construction impacts.
With construction traffic coming and going, and the residents who are already there in Windsor Close and their own car parking situation, and I just, could you explain it, please? How you envisage it working, because it just seems so narrow.
Try and deal with it in 3 ways then. The width issue, you're quite right, the pinch point width is 4.57 metres, but elsewhere along Windsor Close the widths are greater than that. They range from 5.18 metres just by the radius coming off Manor Road, through to, well, 5.2, 5.6 at the far end. So the widths vary. So there is opportunity along the length of Windsor Close for vehicles to wait while other vehicles pass by the pinch point, as it were. So that would be a normal sort of operation anyway. In terms of the pinch point width, 4.57, within our design guidance, planning streets and places, we allow pedestrian prioritised streets to have widths of 4.1 metres or more. So 4.57, although it's on a radius, does comply with the width requirement that we would specify if as a minimum. In terms of construction impacts, we have a condition, I forget which one, condition 19, is it? Or it's a later one. There we are. Sorry, condition 11.
It's not, no.
Condition 9? Sorry, condition 9 requires the applicant to submit a construction method statement or construction management plan prior to commencement of development, and that would deal with looking at traffic impacts during construction, and within that we'd be looking at one of the requirements would be to ensure that we can get construction vehicles along the initial section of Windsor Close into and out of the site. So the applicant would have to demonstrate to us that that's achievable with or without traffic management. I think we discussed this perhaps last time. Councillor Lees, I think, raised the issue of do we impose any traffic regulation orders. There is scope for temporary traffic management arrangements to ensure that parking doesn't take place on one side of Windsor Close to maintain free flow along the route. So those sorts of issues will be covered in detail through the construction management plan condition.
Okay, thank you.
Thank you, Joe. Councillor Malmström.
Thank you, Chair. On the affordable housing ratio, if the costs of building this development increase, is there a risk that the applicant could, when it comes back to reserved matters, get out of the affordable housing requirement by saying that the viability assessment has changed?
It's always possible for an applicant to make that case, whether by way of a fresh application or a deed of variation to the Section 106 agreement. They can make the case. It doesn't necessarily mean the local authority has to agree with it, but we can't stop them making that application further down the line. But we've no reason to suspect that that's the likely position in this case, but we obviously we don't know. Obviously, the local planning authority has to assess the application as it stands, which is for 30 units, 10% of which would be affordable. 10%. Sorry, 30% would be affordable, and 9 units.
Laura, any further questions? Then it's Councillor Lees and then Councillor Murphy.
Thank you, Chair. Going back to the photograph with the protected tree, always the no dig method, is it still looking at putting 900 mil on the ground, increasing the ground height by 900 mil, or is it a different method on this application now? That's one question.
There's a condition there that we require the details to be approved because we don't know how much of the design of the cell web needs to be and what that gradient is. So there's nothing been set, and that's why there's a condition that needs the details to be provided and then sign off from the local authority, highway authority.
You know, 900 millimetre was mentioned last time, so if it's got to no dig and you're putting that, increasing the height of the roadway, it's lessening the height of protection for the tree for the bigger vehicles. So I noticed that tree had got some low boughs on it, so I can't see how you can put 900 millimetre on the land and still get an heavy goods vehicle under it. That's question one. Question two is, where the road finishes, where the bungalow's been knocked down, the footpaths end up on the property's gardens. Surely that's not right. You're putting pedestrians onto people's front gardens. Or am I looking at it wrong? It's not a service strip owned by somebody else, it's owned by those householders. unless I've got it wrong.
No, it needs to be clarified, Stuart.
It's on that drawing with the tree protection. The other one, the number 6 drawing, I think it was. That one. It terminates into next door's gardens. Frontages. The footpath does. From the new development.
It does.
Is that correct?
Chair, can I deal with that? On the northern side, I think looking at the illustrative plan as well, that section of width beyond the carriageway on the northern side is service strip. So it continues the same sort of treatment as currently beyond the driveway to number 3. On the southern side, I think it's footway intended all the way up to the site boundary, and at that point pedestrians would have then to move into the carriageway and not use the service strip. So there's no engineering works on third-party land that's not in the applicant's ownership at the point of access.
I'm just concerned that there's no engineering works on third-party land, but it looks to me like it's ending up on third-party land. But that's my question on that one.
No, there's not. Could it deal with the cell web issue, the no dig? In the arboricultural report, it specifies cell web depths of, I think it's 100 millimetres plus tarmac surface. The tarmac surface depth depends on ground conditions beneath. It could be anything up to about 300 mil. So maximum carriageway depth would be, construction depth would be something like 400, maybe 500 mil. And if that's all above grade, then it still allows for sufficient space between the no-dig area and the point of access for the gradient to be achieved at a level that's within our planning streets and places guidance, which is a maximum of 8.3%.
Right, and my final question is going back to Councillor Linthwaite's question about the 4.57 metre road width. It's all right having a little Fiat, but the bigger your vehicle, the longer the wheelbase, so it narrows the road down. So it's not really, if you've got a lorry, it's going to reduce that road down to probably 2 metres because of the length of the turning circle. So that was just a comment. Thank you, Chair.
Councillor Murphy.
Thanks, Chair. Interested in the applicant's RSA. I hear that some of the information in that is incorrect, and it was brought up by some of the speakers tonight. How much interrogation of that RSA have the highways made, and do you fully support what's actually in that report?
That RSA was submitted before we issued our final observations back in August last year, so it was fully considered together with the applicant's design team response before we issued our recommendations. In terms of the suggestion that the report is somehow misguided and doesn't take into account, I think the specific issue was it doesn't take into account the service strips and lack of footways along Windsor Close. Actually, it does. If you were to look at the report, there's the second issue that it identifies. It considers Windsor Close, and it specifically acknowledges that the existing cul-de-sac has no off-carriageway routes for pedestrians. So it specifically deals with that issue. And the recommendation that the safety auditor made to address that was that the shared use along Windsor Close should be formalised with entry treatments at each end of the existing road. And that's essentially what's being proposed, certainly at the eastern end of Windsor Close with the access scheme on drawing P6. At the western end, you've already got the mailmouth radii and the bend, which act as essentially speed reduction features, and you could implement additional measures at that end to control speeds there too. So essentially the submitted access scheme and the condition that we've recommended, condition number 4, which requires details of those measures to come forward for approval at the subsequent stage, cover off the recommendations in the safety audit. And the safety audit is conscious of the shortcomings along Windsor Close.
Any final question, Dermot? If not, yeah. So I'd like us now, I think everyone's actually asked a question apart from Councillor Bates. John, do you wish to? You're okay, right. So we're going to move now into debate, and to save a little bit of time, in the sense, is someone prepared at this point to put a motion forward? The officer recommendation is consent. There may be members that wish to put something different, and then we can debate the motion if it's seconded. Councillor Lees. And you with Peter, a ward member for this area.
Yes, thank you, Chair.
Yeah.
I'm the second ward member, yeah. We've heard some really good comments tonight, this evening, and the other night. Unfortunately, I wish to move this application against officer recommendation. My reasons in doing this is that this outline application for the application of up to 30 dwellings and associated access fails to address some major issues which have been discussed tonight on many occasions, for which some will come up under reserved matters when the detailed application comes forward. But other conditions don't address the problem and issues this development will create if allowed. Again, local residents have voiced their concerns both tonight and in the written objections, with very little attention being given to them, especially on the drainage issues. Policy S1, maintaining and where possible enhancing accessibility to a good range of services and facilities, and not putting an unreasonable burden on existing infrastructure and services. This application has inadequate width and geometry for Windsor Close to be a through road with only a width of 4.57 metres at its narrowest point, and DCC has stated it is unsuitable for agricultural vehicles. So why would construction traffic be acceptable when most of them are larger than agricultural vehicles? I feel if allowed, this would put unreasonable burden on the infrastructure in Windsor Close and its residents. Policy S4, this development is outside the development boundaries and will be a development in open countryside which sits in the parish of Offcote and Underwood, not Ashbourne. Policy S8, Ashbourne Development Strategies, this development fails to meet paragraphs A and D. Policy PD1, this development fails to meet the requirement to be easy to move through and around. It does not have a safe pedestrian routes throughout Windsor Close, with no definite traffic calming measures which could be implemented. Only one of DCC's perimeters for shared surface environment is compliant, with the rest not being achievable, including the provision of footways. It is doubtful the requirements of PD8 can be met, which details will come forward should permission be granted. Policy HC19, accessibility and transport. As one of the speakers spoke about earlier on, the nearest bus stop is on Green Road, which is further than the recommended distance away. I think 400 metres is the required measurement, but we're looking at more 600-700 metres. Footpath 15 is accessible via Acklow Brow, which is very steep and will require residents to travel up a steep incline to access it, and the same process to get off the site onto footpath 15. And I believe footpath 15 is under a different ownership, although a public right of way is in place, alterations to the path would have to be gained from the owner. Highway safety, again, is a great concern of mine, with nearby schools, nearby roads, already congested at school times, with no work suggested to the Greenway junction. The farmer's right of way is off a very poor track, only suitable for small agricultural vehicles. With the above and what the residents have provided us with tonight and the previous meeting, I urge you to go with my recommendation to refuse this application. Thank you, Chair.
Thank you. Does this find a seconder first? Councillor Murphy. Now, before anyone speaks, is the committee supportive that we pass what's required to enable the meeting to last another hour, please? And someone move that to 9:30. Joe seconded that. All in favour? Thank you. Right. Councillor Murphy, would you like to comment at this point, please? And of course, Stuart, you have the right to wind up.
Thanks, Chair. I'm quite happy to second the motion. There are many questions this evening that have not been answered in a satisfactory way. I'm confident that the many residents here tonight would agree with this, and I would thank them for all the detailed research and work they've done on this application. It's been very useful and very helpful. The unsuitability of Windsor Close for two-way traffic is very obvious to anyone who has visited the site. The thought of pedestrians sharing the carriageway with increased volumes of cars, vans and trucks is alarming. The number of pedestrians will increase with the new housing if allowed to go ahead, and therefore the probability of an accident occurring is much increased. In every other area of life in this country, we work hard to minimise the risk to health and safety for good reason. The alternative routes discussed tonight are not quality alternative routes and have their own problems. I've walked these routes and they are not satisfactory. I would not let my daughter walk on these paths of an evening, and the surfaces are poor and the lighting is next to non-existent. Why is the bar being set so low for health and safety with this application? I find it concerning that officers of Derbyshire Dales District Council and Derbyshire County Council are agreeable on recommending this application for approval, even though there are clearly questions that have not been addressed to a satisfactory degree. Highways and drainage issues are to the fore, but not the only ones. In principle, I do understand we have unfair housing targets to meet. We as councillors, we are under pressure to approve applications. However, these targets do not trump the safety and well-being of our residents. As councillors, we have a duty to make judgments that take into account the obvious facts and shortcomings of any application presented to us. I note the large number of conditions so far for an outline planning application. I'm not confident that we have the resources to enforce all these conditions that have been applied to this application. I'm echoing the same point raised by an enforcement officer at one of our meetings recently. Sometimes conditions are the difference between approving an application and not. So they are important. The phrase tilted balance is presented to us as a reason why we should look favourably on an application. In some situations, that might be acceptable. However, Windsor Close has issues that potentially could jeopardise resident safety and potentially damage local properties close by due to flooding. I cannot support this application, and there are too many issues that have not been addressed in a satisfactory manner.
Thank you, Councillor Murphy. I think, Chris, you would like to come in at this point, and then we'll carry on with the debate.
Chair, I think as put on the table, there isn't planning reasons for refusal need to be concise, and I've certainly picked up on a number of points that have been just said. Failure to demonstrate suitable drainage strategy, failure to demonstrate safe access to the development. Those, whilst I might not necessarily agree that they are strong reasons for refusal, could form the basis for reasons for refusal. In relation to the other points, I think I've got picked up on contrary to policy, site is in the open countryside. As I said before, the site does comply with policy S4. Our policy team have confirmed that, because it's a first tier settlement, and where you can't demonstrate a 5-year housing land supply, then the policy then that is allowed. So I don't think that would stand up. In relation to public transport, we've heard from our highways officer tonight. I would caution the committee against going against the advice of the Highways Authority, and also going back to the point about safe access. I would strongly caution the authority against. I've not heard any evidence tonight to suggest that the advice being given by the Highways Authority is anyway substantially deficient. So I would just make those comments, but also more generally, I think reasons for refusal need to be much clearer and more concise than what we have, which is just generally a list of objections to the application, which will not stand up to scrutiny at appeal.
Stuart, just before you come in, could I just invite Councillor Dobbs? You've had immense experience with appeals and various things. It is part of your patch. Is there anything specific that if you'd have been sat around the table tonight as a planning, you know, a firm planning reason? Yeah, thank you, Peter.
There may still be a disembodied voice. Thank you, Chair, for inviting me to comment. I mean, I think what Chris has said, that is, we don't have a firm plan for draining this site. I would have thought that's almost by itself would probably be a strong reason in appeal. And the highways issues, there is just too much that hasn't been defined. I come back to the point that I made in what I said, in that there are so many loose ends. It seems to be when you're approving access, you ought to be able to approve safe access, and I don't think we have. So I would, exactly those 2 points would probably be the limit of what I would suggest at this stage, but I think they are more than adequate to refuse it at this stage in the condition that it's been presented, which after all, as we've seen, has so many uncertainties. Thank you, Chair.
Thank you. Councillor Hughes.
Chair, I'm in two minds about whether to approve or to support Councillor Lees and Councillor Murphy or not. I think we've had applications where there's insufficient information provided by the applicant to approve, and this may be one of them. It appears that in terms of the access, we would be being asked to approve what the local authority, what the local highways authority is designing, not what the applicant has designed. And we're told that we should approve or refuse what's on paper from the applicant. So as far as I can see, the applicant has provided a drawing of the access which has footways, and we know there aren't any footways. So we're being asked to approve something which is wrong. Or we're being asked to approve something that is different from what the applicant put forward. And I find that difficult, and I think others do as well, because that suggests that the applicant hasn't provided sufficient information to demonstrate that they can provide safe access. Highways have interpreted what the applicant has provided and said, yeah, if you do this or that, then it will be safe. But that's not what the applicant proposed. The applicant proposed separate footways, and we're not here to approve what Highways has suggested, which I'm sure is quite satisfactory. We're here to approve or refuse what the applicant proposes. So the applicant proposed footways either side of Windsor Close. It's impossible to do that. So should we approve it or should we refuse it? I don't know. I'm not making a point at this stage. I'm just saying that's one of my conundrums. Well, we come to drainage. Now, drainage is an interesting one, isn't it? So we asked for more information at the last meeting, and what we'd got was a lovely coloured drawing with two blue arrows, one going west, one going southeast. Is that a design? Does that demonstrate any further information? We knew that already. What we don't know is what the conditions suggest is that we will never know in public what the drainage conditions are going to, what the drainage design is going to be, because the drainage design will be decided after reserved matters in accordance with the conditions here, and we can't do that. So if Stuart's and Dermot's motion fails, then I've got a series of changes to conditions so that whatever happens, the access and the drainage can be seen at reserved matters and can be discussed and approved or refused at that stage. So I find that there's insufficient information here. With the Gritstone Road application, we refused it because there was insufficient information about a number of factors. And it may be that the same is true here. I don't know. I mean, I think that's for Stuart and Dermot to suggest. But that's the point that I would like to make. Thank you.
Thank you, David. Other members that haven't spoken, Councillor Peacock and then Councillor G.
I'd just like to give the other side, really. I thought that the officers from the Highways Authority and the Flood Authority, I thought their information was really helpful. I'm really pleased they came, actually. Very much like to encourage them to do that more often. And I think, so on the roads, I think it's very hard to envisage, when a road system doesn't exist, it's quite hard to envisage what it's like. But you know what, I live on a road that is accessed by another road. It's considerably narrower than 4.6 metres. And it has considerably more than 30 houses that are accessed via that road. And children walk on it. I'm very happy to let my children walk to school that way. There's no pavement, by the way. It is annoying, and no new development would ever be built like that. But it never causes a problem. It's much, much less of a problem than people think it's going to be before it's built. On the flooding, we didn't ask for a design. We asked for proof that the drain could be accessed on the applicant's land. All right. Now, I think, because I do think, you know, we're paying professionals to do their jobs. I think the applicant is going to have a very difficult time proving that when they have to give those plans to show that they can get the drainage water through that drain, and they'll have to do some very serious diplomacy to get the drain repaired to the point where it will be acceptable. But if they're prepared to do that, I think I'm okay, and I would vote to approve this application.
Thank you, Councillor Peacock. Councillor G and then Councillor Bates.
Yeah, I've got no hesitation in supporting Councillor Lee's revised recommendations to refuse to go against officers' recommendations. For me, we have got an issue on Derbyshire Dales with knowing where we want growth to be focused in future, and that's something that the council needs to decide fairly quickly, because we're working on the basis of the existing adopted plan, but we've got a new environment in terms of housing targets, and I think the council's been slow, and Councillor Dobbs is one of the senior members of the new controlling party in terms of the spatial strategy, and they haven't got anywhere with that. Last week we came up with 4 new options at the local plan committee. I mean, I think that's dreadful, because we should know where we're going to put all these houses. And I think green fields over the settlement boundary in a tier 1 settlement like Ashbourne is just as valuable as a green field in the middle near a tier 3 or 4 settlement. I mean, the Wolds at Matlock was a green field on the edge of a tier 1 settlement, and the residents did the right thing to protect it. You could say it's more important. So, yeah, I'm going to support Stuart's new recommendations to throw this out where it should be, out of the room. Thank you.
Thank you very much. So it's now Councillor Bates, Councillor Linthwaite and then Councillor Burfoot.
Thank you, Chair. I'm going to support Councillor Lees and Councillor Murphy on this one. I'm not convinced about the drainage at all, and I'm also not convinced about the highways. 4.6, I've been down there and it's very narrow. If any vehicles parked there, there's going to be big vehicles are just not going to get past. So I'm not convinced with the arguments, and I'm going to vote with Councillor Lees and Murphy. Thank you.
Thank you. Councillor Linthwaite, please.
Thank you, Chair. I'm going to sound like a broken record here, I'm sorry. I did take my headache tablets before I came tonight because I always end up with a headache on planning. I think this is another of those situations where the planning system itself does not help us to provide housing in the places we need it, for the people who need it, the type of housing. The system doesn't really work to help us do that. And I think this is a good example where the applicant hasn't been asked to provide detailed drainage, hasn't been asked to provide detailed highway stuff and how it's all going to be designed to keep it slow and all the rest of it. At this stage in the process, they don't have to, as I understand it, do any of that. And that's the problem we've got, where your heart wants to say no, but the reality of the situation is that we don't. We're going to find ourselves in a very difficult position, I think, if we turn this down at this stage. And I think Councillor Hughes' suggestion that we look more closely at the conditions to try and tighten those is probably the best way forward for us, because even if it were to be approved and the applicant can't then demonstrate, get over those difficulties that Councillor Peacock was referring to, then it won't get built. But I think we have to be very, very careful about doing what we'd really want to do, but isn't necessarily what we can do.
So, Councillor Linthwaite, you could actually move an amendment to the motion if you so, and test the, see if the route that you're suggesting was supported by members.
Sure, we should only be able to move an amendment against the original motion.
Right, sorry. That then. Okay, sorry, Joe. Yeah, Councillor Burfoot and then Laura, please.
Thank you, Chair. Well, I think this is a really unusual application for us to consider, and I've really struggled with this one. What I would say is that planning, as we always say, it is not a science, and it's really hard to go against the advice of our experts, our planning officer, and the local highway authority and the local flood authority, and that's really difficult to do, but I'm going to do it anyway. One thing that I would flag up is I take into consideration the significant loss of residential amenity here. I really do think that's not been flagged up as much as it might have been. Windsor Close was built as a cul-de-sac. It was purpose-built as a cul-de-sac. No one expects a cul-de-sac to suddenly become a hugely extended cul-de-sac. And it's only by the fact that there is this one bungalow at the end that can be demolished, and that goes against my sort of... I don't like that perfectly reasonable property can be demolished. But I'm also very concerned about highway safety. We've got no footways, we've got shared space that I think is of the worst kind, and I really don't think I can't ignore this Tootham RSA report, and a quote which identifies a high risk of pedestrian vehicle accidents if this application was to go ahead, and I'm quoting that. So I take that very seriously, and I will be supporting Councillor Lee's and Councillor Murphy's recommendation.
David, two people have indicated before you, so I will bring you in. Yeah. So, Councillor Maelstrom, please.
Thank you. I agree this is a really difficult one, and I was almost swayed by Councillor Peacock because, you know, I share her concern about the need for housing, and passing up on the chance of 9 affordable homes here is not to be sneezed at. There are lots of issues with this application, question marks as to whether it will ever be buildable. But just sort of my focus is to drill down on the question we're being asked was, is this a suitable access? And I don't think it is. I don't think it's a safe access. In my ward, I have villages, old villages in the Peak Park, which were designed for, horse and carts, and there are constant problems about cars trying to pass each other, and incidents, wing mirrors being exchanged, etc., and people having to jump off the road and try and get their buggies and prams out of the way because there's a delivery van coming and this sort of thing. So we have plenty of places already like that, and in many places in our area, but I don't think we should be building new ones with those problems.
Thank you very much, Councillor Maelstrom. Councillor Peter Slack and then Councillor Hughes.
Thank you, Chair. Yeah, I share Laura's views that it's been very, very difficult, this has. Very difficult indeed. On one hand, you want to affordable housing, we want to support the officers, and so forth, and we need to get housing in the Dales. On the other hand, this was a cul-de-sac, never designed really to be a access road into a big estate. Also, the narrowness of the link road and the heavy goods, it's very, very difficult. I'm still at crossroads now whether to go with the officer's recommended or whether not to. I'm not certain. I'll probably abstain really on this one because I don't want to go against officer's recommendation because this is bringing affordable housing in, and I don't want to go against that, but I'll probably abstain on this.
Thank you very much, Councillor Slack. David, I will allow you back in.
Yeah, in support of what Lucy said, I deliver leaflets on Mornington Rise in Matlock, which is a road of about 47 houses, I think it is. And regularly, I mean, there's no traffic on it. Never has any traffic on it. I mean, it's not noticeable. I mean, there's a car every 5 minutes, as Stephen said. It's infrequent. So the chances of one car meeting another car is relatively low, except in peak times, and people will wait. So we live on off Cavendish Road in Matlock. Now Cavendish Road, as many people will know in the room, from Matlock anyway, is very narrow at the end, and has cars parked there, and often in the pavement, creating a shared use carriageway. Because people can't walk along the pavement because there are cars parked on it, and the road is then only just wide enough for the service bus to get through. So it's akin to Windsor Close. But Cavendish Road supports upwards of 300 houses, and there is a traffic problem there. But the traffic problem is managed and it's not acceptable, but it's lived with. Now, 15 cars an hour is not, or vehicle movements an hour is not a lot of movement, and it's difficult to identify a really high risk associated with so few movements. So I think I'd agree with Lucy that the amount of traffic, even on a narrow carriageway, is acceptable. Now, I still worry about the conditions, and therefore, but I feel that given the planning inspectorate's view on access on cul-de-sacs and their willingness to allow those to be extended, even when the cul-de-sac happens to be a private driveway, as we had in Holland Ward, where a private driveway, because it had agricultural right-of-way to a field, agricultural vehicle right-of-way to a field, was allowed, and that was a significantly narrower space than Windsor Close. It was a space that was blocked partially by a window, and yet and it wasn't built to highway standards, yet and it was on private land, yet because there was a right-of-way, the planning inspectors allowed that to go ahead. Now, if they're allowed that to go ahead, I cannot see how we can possibly refuse on highways grounds in this particular case.
Thank you for those comments. Now, everyone has spoken, so Councillor Lees, you have the right to sum up, please.
Thank you, Chair. Yeah, I'd just like to put in, by no means are we short of housing in Ashbourne at the moment. We've got all the industrial estate which is due to be developed with some 1,200 odd houses. Summing up, I'll refer back to Mr Steve Liverman's comments about would you like blood on your hands from this development? I certainly wouldn't. This is a dangerous highway safety issue in my opinion. I've actually lived on Greenway years ago. It's not a flat playing field. The topography of that hillside is dangerous. You are not going to control traffic coming down that hill through that, the remaining bit of the Windsor Close that will be left. You're not going to control that speed of that traffic. It'll be horrendous. Insufficient drainage detail. We've got no detail on drainage. We shouldn't be accepting maybes and probablys and things like that. We need definite methods. You know, we've got too many conditions on this one and too many unanswered questions. So I remain by my stance. Highway safety. Again, Councillor Burford referred to residential amenity. Them people on that cul-de-sac moved there for probably their last home, without being nasty, but it was, you know, their wish list to live on that cul-de-sac, nice quiet cul-de-sac. Gentleman explained, 90 years old, is having his total life turned upside down if this is allowed. So I will stick by my decision, Chair. Thank you.
Thank you very much. Okay. I too went on the site visit and as Councillor Burfoot's explained, and I do fully understand, and you're probably absolutely right, David and Joe, in terms of how the system will fail us. But sat around this table, we've all got our convictions. And for me, it's always been about serving people. And you're right, Stuart, because the comments from Barry Orme, when you actually said human impact, that's why I'm on this council. And, you know, we are losing appeals because we're trying to defend your corner, and probably I'll get removed as chair of planning for, you know, expressing what I'm doing. But if I supported this tonight, I would not be being true to my convictions. I think ethically as well, to be demolishing a perfectly good home, that didn't feel right to me. And as Barry Orme expressed, you in good faith purchased a home as it is, and to me this is a bad way of doing planning. I can only speak as a lay person, and I will probably be one of the people responsible for this council facing costs, because we are not winning the appeals, and this is the big dilemma, because you want fair representation, you want to see local democracy, and all the time, whether it be your parish, your town, your district, it's two fingers up to us, and the developer takes it to an appeal, and end of story. Anyway, I've had my say, and I want the motion now, please, to be put forward. All those in favour of refusal, please show. Against? One against. Abstentions? Sorry.
Can I just clarify?
Yeah.
Is that okay?
Yes, please.
Sorry, Chair, could I just clarify? So the motion to refuse, I've made the note, is to do with failure to demonstrate suitable drainage strategy and failure to demonstrate safe access to the development site. In amongst the debate, a number of other issues were raised by councillors, and I just wanted to clarify that those are the two reasons, because reference was made to various other things. in the comments that were made just then. So just so that officers get this right.
And the context of the application was outside the plan, the local plan.
It's outside the settlement.
Yeah.
We said that wasn't a good reason. So it's basically on a green field.
Residents' amenity as well, Chair.
So I would just comment that on residents' amenity and outside the local plan, there is extremely high risk of losing on those two grounds at appeal. I would remind the council of the need to be seen to be reasonable appeal. Failure to act reasonably can result in costs being awarded against the council. I have concerns about the two reasons to do with sustainable drainage and failure to demonstrate safe access, but I have particularly strong concerns about the amenity issue and the principle of development being outside the boundary. Obviously, it's for the committee to take whatever decision they wish, but I would just advise there are two reasons there which I would say are very difficult to defend at appeal.
Chris Dale is, in his professional capacity, utterly right to make those points. Now, are we able to meet afterwards briefly with you, Councillor Lees, Murphy? Would anyone else on the basis or does it have to be done now?
Chair, the legal officer may be able to advise, but the resolution has to be clear.
Yeah, thank you, Chair. Just to make members aware, because you're going against officer's recommendation, you do need to be extremely detailed in your reasons for refusal. It is your decision, and we as officers do respect your decision. We're just always mindful of what comes next, and to be able to be in a position to defend as adequately as possible. So as long as tonight all the reasons for refusal are adequately detailed, and Chris will do his best to to put those into a formula. But no, tonight is it. There's no sort of meetings afterwards to decide.
Councillor Hughes.
Chair, that's why I brought up the proposal that it should be lack of insufficient information, rather than so that to make certainly in terms of the drainage issue, there's insufficient information to determine whether drainage can be provided, rather than refusing on drainage grounds. And I would suggest respectfully that we remove the access one, because I think the highways is very clear about the reasons why that is acceptable, and I don't see how we can justify another course without professional input.
Councillor Melstrom.
I voted just now on the basis of refusal for drainage and highways safety.
Yeah.
That was the basis of my vote.
Yeah, thank you. So we're just firming up those aspects. Councillor Murphy.
Thanks, Chair. I hear you, David. And I know it'll go to appeal and we'll struggle. But that doesn't make it right that we shouldn't voice all these concerns that the local people have got and we've got about these safety concerns. Just because somebody in Whitehall will kick it into touch doesn't make them right. They've got an agenda, for housing targets and whatever. I mean, that you mentioned Hull and Ward. I mean, how many pages did they write to justify going against what we had voted on twice, I think? It still didn't make any sense. We still have those, just because they've decided that they'll approve it, the health and safety issues don't go away. We might be reading in the Ashbourne News Telegraph in 6 months' time where little Johnny got clipped by a car or something like that. As David said, we've got a moral duty, really, to do the right thing. I understand, what's going to happen. We're not naive. But, we represent these people, Often we get applications and we don't have any issues with them at all. And then we get these. And, it's obvious that there are things that we've got to stand up for.
We saw the Wolds one. I think the Wolds one is a perfect example where if the council sticks by the residents, all these people, and go with them, you can still win it, because that's what happened with the Wolds. Well, it didn't happen with the Wolds, but the residents won it, didn't they? And it was exactly the same situation.
We've taken the vote. Just a final comment from you, David, but then we must move on because...
Thank you. Quick final comment.
Yeah.
Thanks, Dermot. But the issue is, if it goes to appeal, then we'd have no say over what the conditions are that are applied. And if we get to reserve matters, we get a second bite at it. So, but I mean, this will come forward again at reserve matters, because it's only outline planning permission. So even if it gets approved at overturned at appeal, it'll come back at reserve matters.
Okay.
Councillor, I've got highways and I've got drainage, the two reasons.
Reasons, yeah. Thank you very much, Chris. Oh, and residential amenity.
I don't think, no, I've only voted on residential.
Yeah. Okay, that concludes the application. If members of the public wish to leave the chamber, or you can remain for the rest of the meeting. We've just got to take... Sorry?
What was the vote afterwards?
It was passed for refusal. Yeah. So...
6 against, yeah.
6 against and 2 for consent.
Abstained, yeah. There was 6, well, for the refusal.
6 for the refusal, 1 against and 2 abstentions. So the motion was carried.
There was at least 2 against, because I was against and so was David.
2-2-2.
Right, so it was 6 against 2, no. Right, we need to take the vote again, please, because I'm not comfortable. Right, let's get this absolutely right, please. Those in favour of the motion that was put forward for refusal, please clearly show. Against? Abstentions? So the motion was carried. Thank you very much, members. Are we all right, John? Now, thank you very much. So back to the planning appeal progress reports. Does any member wish to make comment first on the first page? I mean, one pertaining in the central area. Sadly, we've lost on Wheatley Road, 2 Dales, and that, I think, information was supplied today to councillors via an email with the inspector's report, and that was the land pertaining near to the mushroom farm at the top of Wheatley Road, 2 Dales. I mean, I was surprised in that the planning inspector on 2 previous occasions had turned down developments in that particular location, but on this occasion, as you'll read in the report, he felt you know, that was acceptable. So if we turn to page 73, does anyone wish to comment about the appeal decision that we lost? Now, is this Councillor Boyington's ward? Yevely. Is it Councillor Boyington's ward, this? It's Councillor Bull, is it? Right. And then on, yeah.
I know, but it's been a... They've got it, I think.
Yes, yeah. And then page 75, land adjacent to the old schoolhouse, Kirk Ayrton, and thankfully that the appeal was dismissed. Any comments at all? If not, is a member happy to move that we accept the Councillor G? Thank you. Seconded by Councillor Slack. All those in favour, please show. And that appears to be unanimous. So that does actually conclude the meeting. Thank you very much, members, and I wish you a safe journey home.